I mean, they're Good morning, all.
Good morning, Commissioner. Since no one else responded to you, I'll respond.
Yeah, just silence.
Hello.
The voice in the void.
I was going to
Morning.
ask,
Bunch of snow, we do.
yeah, my wife was going to drive up to Santa Fe this morning, but she decided to wait till tomorrow.
The roads, I don't know what they look like between there and here, but outside my window, they don't look bad.
My honey's a wuss when it comes to ice or snow driving.
Well, yeah, and sometimes it's not, there can be the wind blowing the snow onto the roads. That can get to be sketchy.
Yeah. Yeah.
If you can take the roll, please.
Yes, I will. Thank you, Commissioner Maestas. Commissioner Maestas,
I'm here.
Commissioner Fishman,
Here.
Commissioner Byrd,
I'm a present.
Commissioner Hall, Commissioner Vicente Aguilar.
Here.
Mr. Chair, we have a quorum. There are 4 commissioners present.
Thank you,
Oh,
Judy. Commissioner Fishman.
I may, yeah, Commissioner Byrd, I don't know if you're a present, but sometimes you're a gift.
Oh, that's a stretch.
Thank you.
Well, Commissioner Fishman, since you called attention to yourself, why don't you lead us in the Pledge of Allegiance and the State Pledge?
God, he's brutal. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Cynthia, are you going to help me with the state pledge?
Uh,
I
Because I'm
salute
always
the
forgetting
flag
it.
of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you. That's teamwork.
Thank you.
And let the record reflect that Commissioner Hall is present.
Welcome, Vice Chair Hall, and thank you for rescuing Commissioner Fishman on that.
Thank you. You're quite welcome, Mr. Chair.
All right, members of the commission, you have the agenda before you as presented. I do know that we do have one change, and that is to pull
Mr. Chair, Section 10, Item 10, discussion potential action regarding New Mexico Energy Survey. I would like to remove that from the agenda.
Okay, so we'll be removing item 10, discussion and potential action regarding New Mexico Energy Survey. And we're also going to be pulling item 8, or part 8, item 7, 21-00033 UT in the matter of P&M's electric integrated resource plan for the record of 2020 to 2040 in compliance with NMAC 17739. Any other changes besides those two to the agenda?
I wanted to pull one item off the consent agenda just for a brief comment. And that was the, in the matter of the gas company's energy efficiency program, Zia Gas.
Okay, Commissioner Fishman, so you want that heard right after action on the amended consent agenda?
Yeah, just for a couple very quick comments.
Okay, so we have 3 proposed changes two removals and a consent agenda item removal for standalone action. Do I hear a motion to approve the agenda as amended?
So moved.
Second.
Okay, we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Roll call vote, please.
Yes, Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Maestas.
Aye.
The agenda as amended passes 5-0.
Thank you, Judy. So my understanding is we have no special guests and no public comment. Is that still the case?
Yes, Mr. Chair, that's accurate.
All right, thank you, Sarah. So let's move on to item 6, consideration and approval of prior meeting minutes, specifically the minutes of the March 9th, 2022 open meeting. Commissioner Byrd.
Thank you, Mr. Chair. So I do have an amendment to the minutes, Mr. Boaz. It's under section 1, 21-00186-UT, the matter of Southwestern Public Service Company, potential order, down in discussion. And sadly, my iPad doesn't put page numbers, but on down in there, there's a single line that says a refrigerator replacement was proposed to be brought back. It should be refrigerator replacement program, not just one refrigerator. Otherwise, that is my correction. Thank you, Mr. Chair.
Okay, do you want to put that in the form of a motion there, Commissioner Byrd?
And I will move to accept the minutes as amended with the correction of replacement program.
Okay, we have a motion on the floor to approve the minutes as amended. Do I hear a second?
Second.
Second by Vice Chair Hall. Any discussion on the motion? Okay, hearing none. Judy, roll call vote.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall.
Aye.
The motion passes with approving the minutes as amended, 5-0.
Thank you, Judy. Let's move on to the consent agenda. As you recall, we had one item pulled for consideration, and that was item B4. So before we have Judy read out the captions for the consent agenda, I'd like to entertain a motion to approve the consent agenda as amended.
So moved. Oh, go ahead.
Okay, we have a motion by Vice Chair Hall. Do I hear a second?
Second.
Commissioner Fishman, thank you. Any discussion on the motion? All right, Judy?
Yes, the consent agenda items are case number 22-00036 TRM in the matter of the formal complaint of Melissa Garcia and Justin Strickland against AK24 Towing. Then we have case number 22-00038 TRM in the matter of the application of Shuttle Tows LLC for a certificate to provide general shuttle service. Last, we have 22-00055 TRM in the matter of the application of Bernalillo Healthcare Corporation DBA Albuquerque Ambulance Service for reissuance of certificate number 01168 to provide ambulance service. And the other consent agenda item was removed, case number 21-00222 UT, that was moved to regular. And would you like me to take the roll call?
Yes, please.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Fishman.
Aye.
The consent agenda items that I just read off have passed 5-0.
Thank you, Judy. Let's move on to our first regular action item that was a part of the consent agenda. It's in the matter of case 21-00222-UT in the matter of the application by Zia Natural Gas Company for approval of its 2022 to 2024 energy efficiency program pursuant to the New Mexico Public Utility Act and Energy Efficiency Act. So Judy, are you going to kick this off?
Yes, and I don't know how much of a presentation the commission would like on this, but this matter comes before you today upon the September 10th, 2021 filing by Zia Natural Gas Company of its application for approval of its 2022 through 2024 energy efficiency program, and upon the recommended decision issued by hearing examiner Ashley Shanauer on March 10th, 2022. Ashley is here and can summarize the RD if you would like, but the proposed order would adopt, approve, and accept the RD in its entirety and close the docket. And with that, I would hand it over to Ashley to do a summary of the recommended decision.
Before I do that, Judy, let me ask Commissioner Fishman, how would you like to proceed, sir?
Thank you. Yeah, I don't think we need to go through a summary, and I don't have any problem with the recommended decision. I just wanted to take this opportunity to point out that under the current law, we have incentives under this energy efficiency program to install gas furnaces and gas water heaters. And it seems to me that policy has moved ahead of statute at this point. And there's a push towards electrification. And while under the current law, this is a perfectly acceptable energy efficiency program, I think everyone should be alert to the fact that perhaps we need to be updating statute to essentially push towards the electrification that we're starting to see through being pushed through grid mod and other efforts. So I just wanted to make the commission aware, and any policymakers outside of the commission who might be listening in or monitor this meeting, to know that there's something there that we can probably improve in statute. And that's really all that I wanted to communicate on this particular item. And thank Ashley for the good job he did on this.
Commissioner Fishman, would you like to put that in the form of a motion?
Yeah, so I will move to adopt the order.
Second.
Second.
Second by Commissioner Byrd. Any discussion on the motion? I just wanted to, maybe weigh in on that issue, Commissioner Fishman. It's a more general issue in that I think this agency needs to continually evaluate the statutes that we're tasked with implementing and make recommendations more formally in advance of legislative sessions, and maybe target some standing committees to submit a formal letter with recommendations for changes to some of these statutes. I mean, that should be, I think, the primary part of our legislative agenda. So let's note this and keep a running list of any potential changes to statutes. And so let's let this be the first one. Wayne, if we could do that, kind of keep that running list and submit that to appropriate legislative committees, and certainly send it over to legislative leadership well in advance of the next session. Okay, any further discussion? We've got a motion and a second on the floor. Okay, hearing none. Judy, roll call vote, please.
Commissioner Fishman,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Maestas.
Aye.
The motion passes 5-0.
Thank you, Judy. Moving on to another regular action item in the case of 21-00112-UT in the matter of the commission's adoption of rules pursuant to the Community Solar Act. There's a lot of information here, members of the commission, and I wanted to see how you'd like to proceed. I don't know that we need to go through all the documents, but I do acknowledge that the actual rule was just sent out early this morning. And it's okay if you don't feel comfortable acting on this today. You all will have another bite at the apple next week. But what I do suggest is that we go over the expanded version of the order that includes a synopsis of all the comments that we've received. And I think you all saw the format. It includes all key feedback on each issue in the community solar statute. And then it ends with a recommendation from the solar action team and then a recommendation for the commission. And I like this format. It makes for a voluminous document. I think it's like almost 80 pages, but I think we should go through that. I think it would be very beneficial, but I wanted to query you all to see if there's maybe a desire to focus on some of the issues where there was not consensus among the stakeholders through the formal comments, because this will determine how much time we spend on this morning, knowing that we could defer action until next week, until you've had a chance to really look at the rule, which is, I think, Exhibit A. So commissioners, let me know how you'd like to proceed. Commissioner Fishman.
Yeah, Mr. Chair, I think we should defer the final vote till next week. I don't feel comfortable till I kind of go through the rule and I see how all the pieces fit together. It also gives the commission a chance, if there are any minor tweaks, which I assume there'll only be minor tweaks, that we can kind of get our act together and do it in an organized way next week.
Mr.
Now,
Chair,
yes, Vice Chair Hall.
I think that's probably a good idea to not vote until next week. But I wouldn't mind going through all the points. I know it might take some time, but it's an important order. It's an important statute. And I don't think, where the issues are pretty straightforward and it's not controversial. I don't think that would take a whole lot of time. And I just think it would be good for the public to hear everything that's involved in this scheme, this design. And so I'm ready to talk through it.
Right, let me just remind the commissioners that the order, the 79-page order, does have appropriate parts of the statute in addition to the feedback. So it's all like a one-stop shop.
Right.
I really love this format.
I do too.
And so although the final tweaks to the actual order were just sent out this morning, the guts of it is in this expanded order. And so, but I understand we should defer action to next week. So why don't we have, if there's no objection, why don't we have Russell go through the order? But Russell, just, I wouldn't spend too much time on the issues where there was clear consensus.
Right.
So we should go through it. And commissioners, stop Russell at any point if you have any questions instead of waiting till the end. So feel free to pause and ask any questions. Commissioner Fishman.
Yeah, Russell, where there was consensus, please, we probably don't need much commentary on that. Just say there was consensus and note what it says in the rule and then
Okay.
move on.
Okay, I will go. I'm going to go through these. Even when there were debates, I will quickly go over I will summarize them in a brief manner because I think most of the issues can be summarized that way. I'm sorry, can you hear me? Am I speaking too quietly? Let me speak up.
Russell,
Okay. Yes.
before you begin, can you share your screen? That way we can follow. Oh, wait, this is an order, so we can't display it, right?
Well, it's up to the commission. We do sometimes display proposed orders. It may be helpful in this case because it's so voluminous.
Yeah. Is that okay? Let me
there's
ask Judy. Judy, is that okay if we have Russell share a screen and display the order as he goes through it?
Yes, because again, as Russell said, we have done this when we are looking at a proposed order which may be subject to change, and it's okay.
All right, Russell, please share your screen and then proceed.
Yes, share screen or adopting rule. This one need to be. Here we go. All right, can everyone? Yes, looks like it's working. So I've gone down to subject matter number 1. The first subject matter was the administration of the community solar program. The question of who would be the program administrator. When I say use the word program, the community solar program is the name for the entire assemblage of things going on in community solar under the Act. The entire statewide program of projects and participation by the utilities and subscriber organizations, which are the developers and operators of solar facilities, et cetera. So it's the whole shebang. And there was not much debate here. Most people believed that the commission should either administer the program itself or use a third-party contractor. And the team's recommendation is to use a third-party contractor. They'll be performing functions such as conducting the request for proposals process, which I'll be describing in more detail later, for selection of projects to go forward, projects, community solar solar facility proposals to go forward. Someone with experience, we've issued the RFP already, although as I note in this order, we've only issued the RFP for that. So for that position. So the commission hasn't committed to it. The commission could still decide, based on the discussion this week and next week, to reject the team's recommendation for a third-party administrator. But I think that was a very popular option because that keeps the commission the commission. It will be contracted with the commission. They'll be working with the commission, and they'll be applying. That administrator will be applying the various, sometimes very specific criteria and other restrictions of the rule. So they'll have a clearly defined role. And there's some other roles of the administrator that will come up as I go through the role. The program administrator will be mentioned. That'll be the third party. And we've actually already, as I will discuss a little bit more later, contracted with a couple of service providers. The commission has just on a short-term basis, so that this program can hit the ground running. for certain for community outreach, which is not so much of a program administrator function, but to also on the other hand, the other service provider. I wish I could recall exactly what their services will be providing, but we'll be providing some program administrator type services in the meantime until program administrator is chosen through the RFP process if the commission decides to go that route. Sorry about all that background, but this involves the contracts that are an RFP that are pending, contracts that have been entered into. Just want to clarify that. I hope I did clarify that. The other option was having the commission do it itself with the commission's own personnel. Obviously, the team recommends the third party because the commission lacks the expertise and lacks the personnel, certainly, and extra staff time to devote to undertaking all the duties involved in administration. So I think the team's recommendation makes a lot of sense there. Some of the utilities, maybe all three of the utilities. This is the three electric utilities, EPE, PNM, and SPS, which are labeled as qualifying utilities under the Act. They did suggest that the utilities themselves do this. Only they suggested that. This did not seem like a good idea because there could be potential conflicts. The utilities themselves, as I noted in my memo, are generally, I think it's safe to say, reluctant participants in the community solar program. They're not the proponents of the program. They take on duties under the program and sort of lose a little bit of control over the grid under this program. And so we thought a third-party administrator with expertise, neutral, would be the best way to go. So I'll take any questions if there are on that.
Russell, can you just maybe mention the advantage of having a third-party administrator with respect to retaining the fees that are charged for program applications and things like that?
I might have to refer that to Art. I understand that, we were able to obtain during the comment period, we didn't yet have a budgetary appropriation for that specific issue. And I don't know if I'm as familiar as say Art is familiar with that issue. There was a question, as you know, in the Act, as you may recall, the commission is able to charge an application fee to subscriber organizations, AKA project, bidders with community solar projects in the RFP process that can be used to defray the costs of the commission's, the administrative costs of the commission with regard to administering the program. But the Act said that the commission couldn't actually retain those fees, had to turn them over the general fund, and then the legislature could decide how much to budget back to us. I hate to say it, Commissioner Masses, but I don't. I guess if my understanding was that in the budget that we had been given authorization to retain those fees, but maybe it's only because we use a program administrator. I myself am not sure if that's a decision.
Russell, I'll just defer until you get to the part where you discuss the fees, because I think there's some language in there that we may be able to get around having to send any revenues from the fees to the treasurer by providing it to the administrator. And so I'll just defer that until we get to the part where we talk about fees and what's done with the fees or the revenues.
Okay. Commissioner Myers, I see what you mean. Yes, I mean, under the recommendations here, the administrator would collect and retain the application fees. So they wouldn't enter into the commission's hands. And that may serve that purpose with regard to avoiding having to return those to the general fund. So I'll move on from that. But are there any questions about the choice of a third-party administrator as the third-party contractor as the administrator?
No, but I do have a quick question on the funds, which is
Commissioner Fishman.
So essentially, if they have collected excess funds, it basically just sits in their kitty, if you will, to be soaked up by future billings. Is that the mechanism that happens there?
Yeah, this rule actually doesn't specify it has the administrator collecting the fees. There aren't a lot of specifics about how the administrator handles those fees. Obviously, the administrator would be essentially holding them in trust, on behalf of the program. I don't have a lot of specifics on that issue. I don't know. We do have Art available for questions, but I don't know that Art was involved in some of this process. This is not something that is that the rule goes into any great detail about, is the handling of the fees. But yes, the administrator collects them. I don't know if Art,
fine with that.
Art, if you have anything. Okay, you found okay. Sorry about that. Okay, I'll just move on to the next issue then. If there's nothing about, another one has any questions about the actual choice of administrator, that RFP is pending. Okay. Subject number 2. The act specifically requires the commission to adopt consumer protection measures for subscribers. Subscribers are the people, the individuals, or they can also be small commercial. They can be members. Subscribers can be members of the residential rate class of any utility, or the small commercial rate class of any utility, in addition to other ratepayers for utility that are specified, such as I believe tribally owned businesses, nonprofits, et cetera. There's a whole list, but those are current ratepayers of the utility, of any of the 3 utilities that can become subscribers to a community solar project to the extent that a community solar project is made available to them in their area. So the subscribers are really considered the consumers. They're the people who may not be knowledgeable about community solar and would become involved, would be signing up with subscriber organizations, which are the developers and operators of projects via subscription agreements. So the commission is charged with, and here's the portions of the acts that where the commission is charged with regulation of subscriber organizations and oversight and review of the consumer protections established for the community solar program. Again, consumers read that as subscribers. And then also to provide consumer protections for subscribers, including a uniform disclosure form. And there's specifics there. This rule includes specific disclosures, and Exhibit B to the order is the team's recommended subscriber information form, including such disclosures. Let's see, I'll move on. I'm going to move on. There's some other provisions here that about the bill credit. Those are provisions about the bill credit, also have to do with consumer protection, but they're dealt with later in the order. So there are specific.
Russell?
Yes.
Will you be going through the disclosure form? Would it be beneficial since we're on this section?
Yes, I can do that. I was first just going to give an overview of the approach to the team.
All right.
But yeah, we could definitely go to the form at that point. So I think it's a good idea. So what I was going to say is there's also in the act a couple of requirements for subscriptions agreements that all subscriber organizations must apply. Those are not recreated in the rule. This rule does not recreate any requirements that are already in the act, because that's generally rules should not do that. Sometimes there's a little bit of language recreated in the rule simply so that it makes sense to go on and then refer to what the rule is adding. But let's see, let me move past that. I'm just going to pass. So I have the proposed rule language from the proposed rule, and these are the issues that were raised for under the issue of consumer protection. But I'm just going to give an overview because there are two major areas, two major questions. There are many sub questions, but two major questions for the commission with regard to how to regulate subscriber organizations. Excuse me. We're required under the act, the commission is required to require disclosure in a disclosure form, and the team recommends that and has provided that, and I'll show that in a moment. But many of the commenters, or some of the commenters, such as SPS, I believe the city of Las Cruces, some other commenters, recommended a number of that the commission impose a number of mandatory subscription agreement terms. The subscription agreement, of course, is the agreement between the subscriber organization and the subscriber. And in addition to the disclosures that would help a subscriber understand the risks and potential benefits of entering into an agreement, there were recommendations to add many required terms that would have to be in every subscription agreement, such as guaranteed returns or guaranteed the guaranteed ability to opt out and receive your whatever you had already paid in terms of costs to the subscriber organization. The team is not recommending that the commission include subscriber agreement required terms, or that the commission pre-approve subscriber review and pre-approve subscriber subscription agreements. And the reason for that, I like to get down. Instead, the team recommends the disclosure approach at this point. And I do want to I want to make sure I mention all the reasons for that, because it's this is one of the most important points where there is a great deal of this is a major policy decision for the commission here, which would be just let me find those reasons, because I want to make sure I mention all those. One of them is that obviously requiring a lot of terms in the subscription agreements, is taking away a lot of the independence and freedom of the subscriber organizations to create the sort of relationship that they want to, that they have in other states as developers. So it may restrict the interests of subscriber organizations in participating in the program. And one of the things that the commission is instructed to do in the act is to reasonably allow for the creation, financing, and I don't recall exactly the third item, but we're supposed to facilitate and sort of encourage participation by subscriber organizations in the program. So we thought that heavily regulating their agreements the team thought that would be would sort of smother that. And also, heavily regulating those subscription agreements, that would be something where that would create duties for the commission to then enforce and hear complaints about areas where these particular requirements weren't being followed. And if they were particularly onerous, then they might lead to a lot of disputes. Now, the commission will have grievance and enforcement procedures. Those are included here. But again, the more regulation that's added to those agreements, the more substantive issues will have to be decided by the commission. And that commission, of course, has limited resources going forward. I just wanted to differentiate. The program administrator will be doing administrative type duties regarding the program. The commission will, of course, have the usual duties that the commission has under any statute that it administers, which is grievance procedures, complaint procedures, enforcement procedures, and obviously issuing rules, et cetera. Those are things that can't be given to an administrator and shouldn't be. So having a more limited role, focus on disclosure to subscribers, assuming that subscribers who are well informed can make decisions themselves, assuming that subscriber organizations can create agreements that are fair, but also meet their own needs. That's the approach that the team would have the commission take with regard to the regulation of subscriber organizations. But under the Act, I believe the commission could go farther, because the commission could, reject the team's recommendation and decide in favor of adding requirements to the subscriber agreements over and above the two that the Act already requires. And the two that the Act already requires is just that subscriptions be portable, a subscriber subscription be portable within the utilities territory. I guess if someone moves within that territory, the subscriber, and that the subscription agreement assign no more than 100% of the subscriber's individual average annual electricity use as the subscribed portion of the overall production of the facility, so the solar facility project, to that subscriber, which makes sense. So that you don't have subscribers actually paying for more energy than they would use. So let me take any questions on that choice. That's a major choice here, is to go with a basically disclosure only regime and not a subscriber agreement heavy regulatory heavy subscriber agreement regulation regime, if that makes sense. I hope I made that clear.
So, Mr. Chair?
Commissioner Fishman.
Yeah. So Russell, are you going to go through the disclosure requirements as
Yes.
we move forward? Okay, great.
Yes, I'll do that right now. It makes sense to do that right now. So let me I have to stop sharing this. I have to start sharing that. Let me find that quickly. It's the one thing I did not have open from this is that. So what I have it right here. Exhibit B. Here we go. There it is. Let's see if I can do that now. Share the screen. Here we go.
Russell?
Yes.
Mr. Chair, Russell.
Chair Hall.
Are these disclosure requirements going to be the same that items that are listed in section 17.9.573.17 in the rule?
Yes, in the rule that I provided this morning, you can find those in the, I think it's
it's in paragraph 42 of your document that we're looking at, I think.
Yes, and then it's also in the order. The order itself actually lists them. I'll get to that part of the form. This form was designed, I think, mostly by Art, but I think he used a template from another state that is doing community solar. It's a very good form. Describes, first of all, how right here how the actual subscription works in terms of the energy that's provided and how it's paid for. Subscriber information, subscriber organization information, both the parties to the agreement, because this is a form that will be signed and that will be kept on the rule requires to be kept by the subscriber organization for potential and provided to the commission upon request of the commission. I didn't think we needed to keep these in the commission's or the team didn't. Or I didn't actually, when I was doing the rule, I decided myself that these could be kept, these forms could be kept by the subscriber organization itself, pursuant to a requirement that they keep them so that they wouldn't have to all be filed with the commission. The commission could change that, of course. The project information, terms and conditions. Now, these terms and conditions, you'll see, this is where the commission might decide instead, to have actual required terms. But instead, this simply says what subject matters the agreement has to address. It doesn't say what the actual term has to be, what the content of the term is. Just that the agreement should obviously address subscription size, all these sorts of things, and then both subscriber initials that to show that the agreement includes all that and they understand that. So there are some particular items here. Describe the process for customer notification if the project goes out of service, process to notify subscriber of any changes that would affect the subscriber. Those are things I think that would generally be required, that a subscriber organization would generally include in their subscription agreement anyway. Nothing, and this is the form. The form, of course, is referring to things in the agreement because the agreement defines the rules. But there's some specific notes here. I'm gonna go right past those just to get where am I here? It's the actual. I'm sorry. These terms. These are the 10 things that are actually listed in the these subject matters for the agreements are the 10 things that are listed in the actual the rule itself, and they're just included in this form because the form is the rule is basically saying what the disclosure form is about. So these are the things, again, these are the subject matters that need to be in the agreement that would ordinarily be in agreement anyway. And this disclosure has to be made about that the subscriber understands what those are, because those are the critical terms. But the content of those terms, what the what the subscriber organization wants those terms to include as the actual terms are up to the subscriber organization under the team's recommendation.
Mr. Chair?
Commissioner Fishman.
Yeah, so Russell and Arthur, if you're on. So I see those individual items. Is there anything, I guess what I'd like to see for the consumer on this is something that's a quick comparison of the estimated all-in cost versus their current all-in cost of getting the electricity. Does this cover that? Does this give that kind of a?
Commissioner Chair and Commissioners Arthur O'Donnell here. Yeah, one of the elements here would be an estimated payments over the course of a year.
Estimated 1 year, okay.
Yeah, and if that represents a rate discount compared to what the standard utility service would be, and also payment terms. Now, as Russell indicated, we're not specifying these things. These are the things that the subscriber organization is going to put into an agreement. Mm-hmm. And what this form basically does is it forces them to go over the terms with the customer, and the customer sees where those terms are specified and then initials each one to say that they've had full disclosure and then signs the form. Mm-hmm. We are going to be providing a web tool, which really kind of concerns the most important element of this, which is what the solar bill credit is and how that translates into what the cost to the consumer is. And that's something that's being worked out. Miguel is working with a web designer, and we're using a template that's based on Oregon State's web tool, so that we are providing people with a way to understand what their bill impacts is, because that's really one of the make or break issues for these projects.
Yeah, I guess in looking at this, I have this urge to say estimated total 1 year payments, just to be clear that it's the all-in cost, and or some term that makes that a little more explicit. So just a suggestion.
Sure, and we have the ability to manipulate this. This is really a template to be used, right? Rather than
and updated as need
be. Right.
Okay.
And I do want to point out the two things. Russell, if you could go down a little bit.
I make a note here. Sorry, I was thinking to make a note in this document of that. Mm-hmm. Well, I don't know. I didn't.
Okay, then down further, and this is the in case to go up just a bit so that we can see the language on the consumer complaints. Okay, thank you. Right there, and as Russell indicated, the commission is not abdicating right its responsibility to hear complaints from consumers, and so we have existing mechanisms for customers to contact the Consumer Relations Division, and but we're urging people to work this out with the subscriber organizations. This is one of the things that we heard loudly and clearly from other jurisdictions, is that the commission should not have heavy-handed regulation over these entities, but have the opportunity to help resolve issues if necessary, and if there's a serious complaint, right, to refer it to the Attorney General's office. And the Attorney General kind of weighed in on this aspect of the Attorney General's representative weighed in on this aspect of it. Not written here, but what's important is that it was very important for the utilities that they not have to handle all the consumer complaints, right? So basically, if there's a complaint between the subscriber and the utility, it's going to be about the application of the solar bill credit. If there's a complaint between the utility and the subscriber organization, it's about the delivery and the terms of energy delivery there. The commission could get involved in that, but that's better for those business parties because there will be a business arrangement between them. But the complaint between the subscriber and the subscriber organization is something that we have to keep an eye on because it's new, right? It's new to our process. And, you know, kind of like let's just say that we're letting everybody know that we will get involved if we need to, but we're hoping that this kind of disclosure will alleviate a lot of those difficulties.
Yeah, just one follow-up. Have there been with the other states that we've looked at significant complaint problems? And if so, you know, what's driven that?
It's really about, we have not gotten widespread complaint issues. Some states have a much more formalized consumer protection set of guidelines, like the state of Connecticut. But really, we have not heard that much about issues among the parties on this, except making sure that everybody understands what's involved, right? It's really a matter of information. When you look at it, things don't really change, right? What's changing in this is who's providing the energy to the utility and how that gets billed. And so if there are difficulties, it's going to be in the billing.
Okay. Thank you.
And one other thing, and I don't think that we need to raise it, but there is a second disclosure form. And this is a registration form for the projects that are selected. And it's actually fairly extensive in terms of identifying the business structure and who is in charge and what the nature of that organization is and how the commission can get in touch with people immediately. And those would be public documents. The intent there is that the commission would keep those and put them on the website so that there is a public record of who these companies are behind the projects, right? So I think that that's an important part of the disclosure that I just wanted to reference as well.
Thank you.
Yes,
Arthur, I just had a follow-up question.
Yes, sir.
Arthur, so are there any special terms and conditions for those subscribers that qualify under the low to moderate income set aside? Or are they already presumed to be, you know, pre-qualified so that the project can get the necessary credit for the 30% set aside?
Well, that is, Commission Chair and Commissioners, that is exactly what we're working on through the short-term contract with the Community Outreach Group. Community Outreach Group is the Sustainable Communities and Grid Alternatives. And what we have contracted them to do is to develop training tools for community-based organizations that can pre-qualify low-income customers and provide those customers with the consumer education materials that they need. So it's not that there's special terms, but the intent of that is to develop a pool of customers who've already been determined to meet the criteria for low-income eligibility. Okay, this is a direct outgrowth of the Act, but we had to put some flesh on the terms of it. And what we're doing is working with these organizations to determine exactly how the commission is going to identify that. Largely, it's going to be, you know, if you have a Venn diagram, it's going to be almost completely coincident with the LIHEAP customers. But there are also some other ways to determine low-income eligibility, like living in Section 8 housing or participation in some other programs, which we've listed in the rule, but which will be fleshed out through this contract with the outreach team. Does that answer your question, sir?
Yes, thank you for that, Arthur.
Okay.
And one thing I'd like to add to that, Commissioner Myasis, or Mr. Chairman, is that though this rule will not require any particular subscriber protections that apply only to low-income subscribers, the selection criteria for bids, which is a very lengthy part of the rule, includes extra points in the weighting scale when the administrator is choosing projects there are a couple of selection criteria that would award points for certain special protections that the project, the project manager's subscriber organization voluntarily adopts in order to, they get some extra points for that extra consideration in the bidding process.
Thanks, Russell. So go ahead and proceed,
Mr. Chair,
Vice Chair Hall.
a couple of things. I just noticed on the screen there in the paragraph above, the top paragraph there, the value of the solar bull credit is established by, or you got a typo there. I'm sure you want to say bill credit. You see what I'm talking about, right? Okay. But Mr. Chair, I also had a couple of questions. And
Go ahead.
I just wanted to ask Russell, I noticed in paragraph 43 of the order, it follows paragraph 42 that
Did I go back to should I screen share that? I think we've gone through the form. Well, we've gone through the form, maybe. I don't know if everyone's ready for
it relates well, you don't have to go back. I guess you could just look at those points because they may relate to the form. I'm just trying to get some clarity.
Okay.
It's 43 talks at paragraph 43 says there are additional issues that the additional issues included the following. There were additional issues for subscriber agreements that were not contained in this list that that I think we must have just gone through because you said they were the same things that were contained in your form, I think. And these additional issues have to do, there are 5.
Commissioner Hall, these are, if you don't mind, I might be able to clarify very quickly. If you don't mind if I interrupt.
No.
Okay. These in every section under every subject matter, except for a few of the subject matters at the end of this order, every subject matter includes these questions, a list of questions and issues pertaining to that subject matter. And these issues and questions are addressed. They're one for one. They match up below. Like for instance, consumer protection A. Those questions this is immediately followed by comments relevant to consumer protection sets A and B. So each of these, what the structure of the order does is goes through each of these issues. And the reason they're referred to as additional issues is because this is drawn directly from and is in the same order and same type of organization of the additional issues sheet that was attached, or document that was attached as an exhibit to the order issuing NOPR. Because as you will recall, the order issuing NOPR had a proposed rule, but the order also acknowledged that, in the workshop process, we hadn't been able to come up with language addressing every issue that we needed to address. And we also wanted to, some things that we did address in the proposed rule, we wanted to have specific questions answered. So in addition to commenting upon the proposed rule, the commenters commented upon these additional issues, which may or may not correspond to things that are already the proposed rule for the comments. And the comments really, address those questions. And so this order addresses those questions. So that's what these additional issues are. They're the additional issues that were additional in the order issuing NOPR, and they really provide the structure for this order because the commenters address these questions in their comments. Does that make sense?
Well, yes, it's fine. What I wanted to do
I'm sorry, maybe I was way off there.
Yeah, maybe if you're telling me you haven't gotten to these questions yet, that's fine as well. But I didn't see that there were just a few questions I was really interested in. Okay. That related to the question: should the commission require community solar project developers and subscriber organizations to post proof of insurance or a surety bond to cover unexpected disruptions to delivery or bankruptcy termination of projects? If so, what's an appropriate level of coverage? I see later on there's some discussion about requiring $1 million worth of insurance coverage, but and I was hoping you would talk about that a little bit and in terms of, how determining what's appropriate amount. And then you also have a bullet, aside from the dispute resolution provisions included in the subscriber agreement, what should the enforcement mechanism be for ensuring that subscribers are protected? And in connection with that, there was a discussion that I didn't see much resolution about related to Maryland's rules for community solar pilot programs. And they had quite a few consumer protection items that they required to be, it's not clear from how this is written whether they were included in a disclosure form. I believe it is. SPS was mentioning this. And there were a number of items that I thought were very good. And it's not clear to me that that in the team's recommendation that any of those are included. And I wondered if you could respond to that as well.
Okay, so let me start with the insurance bonding issue. Now I'm now screen. Can everybody affirm that I'm now screen sharing the order? Correct. I moved over to the order, and you're seeing that, right?
Yeah, you can do that.
Okay. So if you see paragraph 93 is where the discussion.
I'm
Russell?
not seeing the order, Russell.
Oh, you
It's
are.
not
I
up.
think I just stop share and restart. Okay, that's why I forgot that. So I'll stop share and I have to restart and then pick it. That's how that works. I have to remember that. Here we go. So let me do this now. Okay. Now are you seeing it?
Yeah.
Okay.
Wait, I'm not that far ahead. No, Russell, I'm back on paragraph 43. And then 57 is where all those consumer protections are. If you're going to 92 or 3 for insurance purposes, that's okay.
Yes.
But I want you to
I'm
then
just
go back
going in the
to
order. Yeah.
57 after that.
Yes, Commissioner Hall, I'm just bringing them up in the order that you raised the issues. But yes, we'll skip back to some of the earlier paragraphs for the later issues. So comments relevant to the insurance bonding and amount of insurance bonding requirements refer to, as you said, Commissioner Hall, I'll first skip to the ultimate recommendation, as you said, was to, the team recommends that the commission requires subscriber organizations to carry insurance. This is liability insurance for general liability insurance for incidents that occur, so that to protect the subscribers from liability. Now, the subscriber organizations, maybe Art can clarify. I think are they mostly going to be in the form of LLCs with subscribers as members, or partnerships with subscribers as limited partners, do you think? Because that provides some protection as well from liability, but having insurance obviously will also be important. Art, do you have any comment on that?
Yeah, Mr. Commissioner, Commissioner Hall, and other commissioners. The insurance issues are really about to protect the entire business structure, right? If the project fails, then there'll be insurance. And the terms that were adopted were basically recommended by utility staff in terms of having, it's not different than if I was a PPA signing a contract with utility, it would have this same $1 million liability coverage. What we've made the difference is that if the project is smaller than 5 megawatts, there's a gradation of how much coverage they need to have. And we figured that this was sufficient, right? There will be, in the agreements between the subscriber organization, project developer, and the utility, additional protections in terms of performance, because it is the projects that are delivering the energy to the utility. The utility still has the requirement to deliver energy to the subscriber, right? Whether it gets energy from the project or not. And so that's going to be covered in the terms of agreement between the developer, the project, and the utility as how to protect that part of this big transaction. So this we felt was sufficient and didn't need to be more onerous or less onerous. It really kind of covers the exact same level of terms that you would find in any business transaction between
Excuse me, Art, what,
utility developer.
what is it you considered sufficient, the amount you're talking
$1
about?
million, right? And then a gradation if it's a smaller project than
And then-
5 megawatts, right?
Okay.
Then there would be less coverage.
So, oh, less than 5 megawatts would be less coverage.
Right.
Now, so, and that would be, so what do you mean by less coverage? You mean
You can
less?
see it on the screen before you, is that there were a gradation. While SPS wanted to double the amount of coverage, what we're actually doing is choosing a level that is $1 million between 250 kW and 5 megawatts, $500,000 if it's between 40
Oh,
and
I see that.
250 kW, and less if it's less than 40 megawatts. These projects are almost entirely going to be 5 megawatts, right? So it's going to be $1 million. I mean, every indication that we have is that people are going to size them just because of the costs that are involved in developing projects. There may be a 2 or 3 megawatt project, but that still falls into the category of having $1 million of coverage.
So this goes to interruptions of, disruptions of delivery or bankruptcy or termination of projects as well.
That would be covered by this liability, but also there'll be more specific terms in the relationship between the utility and the subscribing organization.
Between the utility and the
The project
Mhm.
developer.
and the project developer. Okay.
Okay.
All right. And so are you going to address these, the question I had about the Maryland provisions?
Yes, we
or-
took all this into account, and there were quite a number of different approaches to consumer protection that were proposed. And as you might recall, I had established a subgroup to go over the consumer protections, and that subgroup included Kevin Cray from the Coalition for Community Solar Advocacy, Kevin Gedko from the Attorney General's Office, and Anastasia Stevens from the City of Las Cruces, right, to go over this. And the general sense that we got both from the stakeholder group from Stratagen and this particular subgroup was that the commission should not have heavy-handed regulation of the subscriber relationship with the subscribing organization. The Attorney General's office was cautious about that. They said, well, that's our job. And while, you know, we all lean towards the disclosure elements, right, as a way of protecting consumers through information, that this mechanism of allowing for complaints to come to the commission and serious complaints to go to the Attorney General's office was where everybody landed. Now, there were a couple of parties that wanted more, right? That SPS in particular had a whole host of things.
That's what I'm talking about. The ones that SPS mentioned.
We explored what other states did, and I'll tell you that the more requirements that were imposed on this relationship had an adverse impact on participation in the market. For instance, Connecticut had a very detailed 15-page consumer protection guidelines, and they couldn't get projects to sign up. They only have 10 megawatts of consumer solar projects.
I guess what I'd like to talk about, Art, is not just in general what's done, but there are some that I thought were important, and I wanted to know if they were discussed at all. One had to do
And I
with,
placed that, just Commissioner, just to let you know, I placed that paragraph 57, which discusses SPS's comments up on the screen. And they did reference, as Art said,
Thank
reference
you.
Maryland as a model. So this paragraph right here is talking about some of that.
right. Number 2, advertising and solicitation practices, I thought was something that looked important. Subscriber creditworthiness practices, and then geographic marketing practices to prevent economic discrimination and general discrimination prohibitions. I thought all those look like they might be important for our communities, some of our communities in New Mexico. And then further on, let's see. Well, there were some provisions about agents, and I'd be interested to know what the discussion was there. There were a number of, aspects about agent training, agent qualification. I've had agents come to my door and they have all kinds of nonsense they're saying, and people can get confused. So I would like to hear more about why. Well, I guess you told me they don't want to be heavy-handed about it and discourage subscriptions, but I don't understand why something like prohibitions against discrimination would be heavy-handed.
Well, Commissioner, all of these were also elements in the Connecticut rules. And so we talked about those in the subgroup. And I think it really came down to the fact that the commission, if the commission wants to go down this path, it requires a detailed process, almost a second rulemaking about consumer protection. And given the time constraints in getting the basic rule for program administration together by April 1st, we did not have a process or the ability to fully formulate a proposal around these issues. Now, I would recommend that if this is something that's important to you, that we have an implementation docket and we can raise these issues for further work in that implementation docket. But I would not recommend holding off the implementation of the program in order to work these things out, because we don't know what type of relationships the subscriber organizations are going to try and do and how they're going to market. We're trying to head that off through the use of community organizations, which are more trustworthy to subscribers than outside marketers or agents. I would suggest that we take a wait and see approach as to how deeply the commission feels the need to insert this kind of consumer protection mechanism, because it's not necessary in most states, right? Oregon has not had something like this. Minnesota has not had something like this. It hasn't been a big issue. It may be, I would say that Maryland is very different than New Mexico in terms of the types of customers who are involved in the programs. Massachusetts is very different. They don't have that low income approach that we have. I think that this would require a much more detailed and informed decision-making process than we were able to insert into the implementation for the initiation of the program. There were recommendations that we continue to have workshops on this, and it certainly is an area that would be amenable to that.
Okay, that's a good answer. I appreciate that. And the implementation docket. I forgot about that. That would be maybe a good place to look at this. So I appreciate that, Russell. Art. I'm done, Mr. Chair.
Mr. Chair?
Yes, Commissioner Fishman.
Another thought occurs to me, and I don't know how complicated this might or might not be, but if we're taking this kind of light touch regulatory approach, which I'm fine with kicking it off, is that it would be nice if there's a way we could survey subscribers to these services to find out what kind of issues that they face after a year or two, just to see if there's anything in particular that we need to pay attention to.
Commissioner Fishman, that's a very good comment, because that is one of the ideas of the light touch, is to begin with a light touch and see if there are particular areas where the commission might want to take a stronger regulatory role in terms of regulating the relationship between subscriber organizations and their subscribers. And I think, we discussed how, the first 2 years of the program, because we were thinking about at about the 2-year mark, because that's when the commission will have to reset caps, the allocation caps, and probably will be doing more of a thorough review of the first 2 years of the program. But specifically, well, how would we collect that information? Maybe we should have a specific provision for collecting that information from the subscribers, because that was actually something we anticipated would be information we'd want, and that makes sense.
Okay. So I don't want to get into the details of how that would be written in, but just something to think about.
Thank you, Commissioner Fishman.
Mr. Chair,
Commissioner Byrd.
I actually just have an administrative note to Russell. You're making those notes here as red line. When you added that to the table, when Commissioner Fishman first asked a question, you put that in there as a permanent change. And just so it draws attention, you might want to go back and make that a red line as well.
Yes, I was trying to make that a red line and I couldn't get it to work. But yes, I'm saving these separately. These documents I'm using with from what I sent to the commissioners as including notes from this meeting. So it should be okay either way. But yes, I'm glad you are correct, Commissioner Byrd. I was trying to do this as a track change that somehow didn't happen. So, but I will do that. Yes, I'm just making these as notes to myself. I wanted them to stand out. Now, I think Commissioner Hall, was there a third after insurance and after this? I thought there was a third issue and I just don't recall. I'm sorry exactly what that issue was.
Mute, Vice Chair Hall.
Maybe there wasn't. Maybe it's my imagination. I thought there were three.
No, I think these were things, there were items, but they were discussed like pre-approving terms and dispute resolution. So
okay.
I don't need to go into those.
Okay, excellent. So let's see. So we've reviewed the disclosure form. We've talked about this general approach of disclosure versus regulation of the agreements, and how regulation of the agreements, especially, perhaps will be revisited after the first couple of years of the program. So if there aren't any other questions, I guess we can move on to the next
Russell,
set of issues. Yes.
just if it's necessary, it might be good when you cover, after you go over the stakeholder input, team's recommendations, and then the commission decision, perhaps you may just go to the rule and just show that portion of the rule that pertains to these sections as we're covering them.
Absolutely.
Especially if if there's consensus and it's not very complex, maybe there won't be a need for that, but it may be good just to reveal which part of the rule we just covered.
Okay, that's a good idea. Excellent. Let me make this a little bit larger. I hate that this, it's kind of annoying. I'm gonna make this larger. Oh, come on, view. That's large enough, I guess. Okay, can you all see this? This is the rule that I just sent this morning. The red lines that are in this rule are showing the differences between this rule as if the commission adopted this rule, would be the rule that goes into place. This is what is recommended by the team. The red lines here show the difference between that and the proposed rule that was attached as an order to the order issuing NOPR, just so that everyone can see the changes. When it's published, there will be no red lines. It would just be a rule with, so let me get to the portions about that we just talked about. Subscriber protections, subscriber agreements. Where are we here? Okay. So the first area that is impacted by what we just discussed is subpart 16, subscriber protections. So as I said, the first in A, this says the commission has adopted uniform disclosure form as required by the act. This language is directly from the act right here, the black language. And then it added the key contract terms, which are not so much the terms as the subject matters that were listed there on the form. Subscriber organization must provide the form to a potential subscriber, allow them, I improvise this language, but I think it's a pretty obvious language. The subscriber organization will have to provide the form to a potential subscriber and allow them a reasonable time to review the form's disclosures and sign the form before entering into an agreement. The subscriber organization must maintain in its files a signed form for each subscriber for the duration of the subscriber subscription. I added +1 year. You can make it +2 years, +3 years. I must make the form available to the commission upon the commission's request. This form, we could have all these forms filed with the commission, but it seems like this sort of form could be retained by a subscriber organization. And then just if the commission wanted to request it, we would. Whereas the other type of form that was are discussed would be a registration form for the subscriber organization itself to register with the commission. So that would give the commission all the information it needed to understand the subscriber organization and locate it and contact it. So these could be, I think, maintained by the organization itself and just made available to us. B is the insurance
Russell,
schedule.
excuse me. Could
Yes.
you scroll back up for a minute? Okay, for that paragraph, you have key contract terms to be disclosed. This is the totality of the terms so far, correct?
That's the list of those. Yes, exactly.
And these also constitute the consumer protection terms, I guess. Is that right?
The these are what must be disclosed on the subscriber form. And that is, of course, disclosure is considered a subscriber protection measure.
Was that a yes? I couldn't quite follow what you said.
Yes.
Okay.
Yes.
All right. So then there's a phrase, among those terms, you have estimated 1-year payments. Is this a place where Commissioner Fishman was interested in having the word total inserted somewhere?
Yes, we could go ahead and do that. That's a good idea. Since I was going to put it on the form, that's a good idea to put it right here. Estimated total. Very good idea. I'll save that. Actually, I'm going to highlight that too for myself here. So because otherwise it will, as a note, actually. Come on. Oh, sorry, my laptop. There we go. Excellent. Good idea.
Thanks. That's it.
Okay.
Russell,
Yeah.
and then in terms of the forms, I didn't see the form referenced in the rule. Are we actually going to include that as an attachment?
It could be attached to the rule. I simply have the language now says the commission, where I said it will issue, it says has adopted, because I thought by this order adopting the rule, we just adopt the form as Exhibit B, has adopted uniform disclosure form, and then describes the form. We could attach it as well, but to the rule as well, but it'll be attached to the order. It can be attached to the rule as well. I think you can attach documents to a rule or incorporate them by reference, or incorporate them as actual parts of the rule. I'd have to ask about that. I've seen it. I think with regard to, I hate to bring this up, the interconnection rule, that the interconnection manual is actually attached to that rule. I'll see if that's possible to attach actually as part of the rule. I believe it is, but if not, it'll be part of the order.
Thank you, Russell.
I just hated to have to raise the interconnection manual issue. So the next part of subscriber protections is this insurance coverage with the schedule. Says requiring the subscriber organization to maintain the minimum level at this according to the schedule that we already discussed. So moving on from that, the subscription agreements, we refer to them as subscriber agreements. Subscription agreements is what they're referred to as in the Act, so I changed that. There are requirements here that go even beyond the disclosure requirements for terms of the agreement. These are required terms of the agreement, except they're
Russell,
really.
excuse me. I'm sorry. This is Commissioner Hall again.
Chair Hall.
So could you just repeat to me again what the general liability and coverage covers? It doesn't cover termination of service or, unexpected interruptions of service, does it?
No, it's really general liability insurance that was discussed in the comments. In other words, the idea is to prevent the project from going bankrupt because it doesn't have liability insurance, just like any other business that might have an unexpected lawsuit on its hands and have to settle it, and for an amount that might otherwise bring the whole project down.
Okay.
Did you want me to go through the schedule as well?
No. Just go ahead where you were. Go back to where you were.
Okay, so the next section is subscription agreements. This includes a list of the terms that the agreement must include, but it's not actual terms in the sense of what the content, what the requirements and rules and conditions that are in the agreement, just the subject matter, general project information, effective date and term, just what has to be stated. What is the content of those subject matter terms is up to the subscriber organization. The commission wouldn't be mandating that. It's just saying the agreement has to say these things specifically, all of these things specifically. So, this is disclosure as well, but through the agreement, just to make it clear, so that there are no sort of hidden terms or things that are in, agreement can have implied terms. We want these to be expressed. These are things that would be in an agreement anyway, probably. And then at the end of it, because in section C is where I've added a section about complaints by subscribers against subscriber organizations, because those will come up in the contents of their contractual relationship. So I thought I could go under this subpart. Maybe we submitted to the Commission's Consumer Relations Division for informal resolution. The Commission may, in its discretion, refer serious issues to the Attorney General to pursue enforcement proceedings. Just what Art discussed already. I've slotted that in here. I believe those are the only sections dealing with, I think that covered everything that we discussed about what would be included. So those are the sections. And if no one has any questions, we can go back to the order and go to the next subject matter. Okay, I'm going to stop share. I got that right. And I go over to share this thing. Here we go. That's where we are. Okay. So let's see. So this, we've gone all through this subscriber, the questions about subscriber disclosure, subscriber agreements. Just want to make sure I've covered everything. Just go, sorry. These are disclosure as well. Okay. Sorry, I just have to find my way through. Enforcement, which we talked about, complaints enforcement. So make sure I'm covering everything. This could go to, okay. Insurance and bonding, we did that. Okay, so we actually got through the subject matter of consumer/subscriber protection. We're on to issues that are under the subject heading of rate making. This includes, so I've cited parts of the act concerning community solar bill credits. It's the utilities duty under the act to apply those community solar bill credits to the subscriber bills, because these are credits against the charges on the subscriber's utility bill. The subscriber, of course, is a ratepayer of the utility. So this is the big responsibility that's given to the utility. Well, among that and interconnection, but the big ongoing responsibility of the utilities, which they have to add to their own bills, is this community solar bill credit. And we're going to get into the calculation and how that's done in the process for the tariffs, et cetera. But this act is the act is making that the responsibility of the utility to put it on the bill. And let's see what else. Some of these things, I don't think I want to go through all of these. Let's see. Okay, so this is one thing that the commission has to do. This is another part of the act section. This section of the act, subsection 7, is where the legislature told the commission exactly what the rules must include. And one of those things is this. You see, subsection 8 is that the rules must provide a community solar bill credit rate mechanism for subscribers derived from the qualifying utility's total aggregate retail rate. I'm not going to go through all the specifics, but there are a lot of specifics here about how the methodology for calculation of the community solar bill credit. The credit is what, the actual amount, and they will differ, that subscribers will see on their utility bill as a credit against the charges that they have on their bill. And then that's specifically defined. And I'm not going to go through definitions, I don't think, unless you want me to. I've included definitions here too, but the credits are calculated using another specially defined term, the community solar bill credit rate. And that's where the let's see, we get into the details of one of the most contentious issues here, which is calculating community solar bill credits. This is an area where the utilities are, it's really the utilities versus, in the comments at least, the utilities versus the subscriber organizations. Subscriber organizations would like to see the biggest credit possible to attract subscribers and make, their project the most viable. Obviously, subscribers would as well. And utilities see some of the things that might basically see it as when it comes to the size of the bill credit. The issue is if the credit includes certain things, then the utility feels that those are things that are basically being paid by or subsidized by non-subscribing ratepayers of utilities. We'll get into specifics, but that I just wanted to set up that opposition because that's essentially the opposition that you'll see. I guess I'll get into the specifics because they'll make it easier. So the Act provides a specific definition of the solar bill credit rate. And then this total aggregate retail rate, which is used to calculate that solar bill credit rate. And I don't know how specific we want to get into that. I think we'll just go to the issues and then you can ask Art any questions about the controversial issues. But the first first 5 of these sets of rate making issues that were in the additional issues, which you see in front of you, A, B, C, D, E, are all concerning calculation of solar bill credit. And as I said in my memo, this is an area, one of the 2 areas that I see as the most likely to lead to a potential appeal. Because this is a contentious issue, it's a money issue, and the utilities were very much in opposition to basically all of the other commenters who tend to be more in favor of bigger credits. So let's get to the first part of dealing with the solar bill credit, which is an administrative issue. Should the commission provide specific credit calculations or provide only the methodology? In other words, should the commission be providing doing the calculation of credits or the credit rate at least, or provide only the methodology? What most people are in favor of having the commission do the methodology. There were some commenters who wanted the commission to actually calculate the credit amounts. I think for one thing, Art might be able to describe this more, give a better, a more complete description of the reasons why the team recommends just providing the methodology. So we're here. Let me look at this part where we give our explanation. The team recommends that the credit methodology be specified in the rule following the formula specified in the Act. Additional language from the subpart should clarify that customer charges and transmission costs should not be subtracted from the TAR. That goes to a specific issue.
Mr. Chair, excuse me. Russell, I'm sorry to interrupt you, but I had a question that comes up in paragraph 91, which I think it's related to what you're talking about now. It relates to bill credit. It relates to the bill credit and whether there was a recommendation about having the commission include some language clarifying that complaints against utilities under the Act are limited to issues concerning solar bill credits. And it says the team doesn't recommend that such language be included. The team concurs in the understanding that solar bill credit issues appear to be the only new issues presented by the Act that may give rise to complaints. But the team does not believe that additional rule language is needed, as the solar bill credit will be the only new item to appear on subscribing ratepayers' bills as a result of the Act. And then it says, there is thus no reason to expect that subscribing ratepayers will bring inappropriate complaints against utilities based upon a misunderstanding of the utilities' role under the Act. And I just wonder if you could talk about that a little bit, maybe in connection with your discussion of bill credits. I don't know that I follow that logic. If there's something new on a bill that they haven't seen before, and I'm sure they would understand it relates to the solar bill and, the solar aspect of their bill and a credit. But I don't know if I agree that just because something is new that they wouldn't, that you shouldn't expect to have questions about it or confusion. So
So
if you could just hold that thought while you're
Yeah.
talking through this, that would be good.
Well, let me just address that right now. So what this is, the utilities, or at least one of the utilities, asked that the commission clarify in the rule itself that the only issue upon which, new issue arising under the Act, upon which subscribing ratepayers could bring a valid complaint against the utility is the application of the community solar credit on the utility bill. In other words, these wouldn't be issues of so much of calculation of the credit, because calculation of the credit all that will be taken care of via tariffs. But say, for instance, subscribing ratepayer, became a subscriber of a particular facility, and then didn't see the credit on their bill until 3 months later. They might bring a complaint against the utility saying, hey, I expected a credit 3 months ago, and my bill only has a credit now, or something like that. That kind of complaint would be a valid complaint against the utility, and it would be handled like any other complaint by a ratepayer against the utility, because that would really involve, even though it's a subscriber to a facility, it would really involve the ratepayer's relationship with the utility. Because as I said, the one responsibility, the major responsibility for the utility under the Act, that's a new responsibility and something new that would appear on a utility bill, is the credit. So it's proper for a complaint to be brought by a ratepayer against the utility based on that, an issue regarding that credit. And it's proper for the commission to not create a new rule as to how to handle those complaints, because that's not the ratepayer utility relationship, and what appears on the bill should be addressed as per the existing rules of procedure we have for complaints against general utilities. So what the utilities have said is they wanted to make sure that those are the only complaints they would see. Ones about they agree. The utilities agree they will have to handle complaints about that bill credit that's going on their bill. But they wanted us to clarify there are no other types of complaints that utilities should bring, or that subscribing ratepayers should bring against the utility. Any new issues, any issues they have otherwise on community solar are issues that they have with the subscriber organization. And that's true. It doesn't seem that there would be any new complaints against utilities except under this new regime, except the credit. But I didn't feel that, or the team didn't feel, and I myself didn't feel, as the lawyer on the team, that clarification needed to be in the rule. And the reason is this: what I'm saying is that ratepayers are guided by their bill, so they're not going to, they're going to have separate billing. And in fact, there's a section later in this order where the team recommends rejecting a proposal for consolidated billing. In other words, billing by the utility that would include subscriber organization charges. In other words, people will be receiving separate bills, one from the utility and one from the subscriber organization. So the team didn't feel that a clarification was needed in the rule to make it clear to subscribing ratepayers that they shouldn't be suing the utility for things that are on the subscriber organization's bill, because I don't think that would be a problem. This order actually does clarify that. It says, yes, we agree, but ratepayers will understand that because they bring complaints based on their bill. So if they're going to bring something against, they're going to understand when they have two separate bills, what is the responsibility of the utility and what's the responsibility of the subscriber organization, because there'll be two separate bills. Does that make sense?
Well, I hear you, but actually, personally, I recall that when my phone bill was consolidated for out-of-state and in-state services by different providers, I found it much more understandable. I liked a consolidated bill as opposed to two different bills that arrived at different times. And kept me sort of wondering how to keep track of these together. I prefer consolidated bills myself. So,
But
I guess
Commissioner, can I
that,
ask, was that consolidation of two different providers' bills?
yeah.
Oh, interesting. Okay. Well, when we get to that, maybe, well, you'll have a contrary view. It's subject matter, I think, number 10 is consolidated
Well,
billing.
my
But here, go ahead. I'm serious. Go ahead.
Well, but I think it relates to this point about bill
does.
confusion and bill credit and whether or not the utilities are going to be limited to one type of complaint concerning the bill credit. I don't think it's beyond a consumer's grasp to understand that if we want to make that clear somewhere, and maybe it doesn't need to be in the rule. I guess you're telling me there's going to be some sort of language in the bill that directs consumers to the utilities if they have a concern about bill credits. There's going to be information somewhere else in their agreement or something. How do you address that issue is what I'm wondering.
Well, what I'm saying is that the rule as recommended by the team would not include any such explanation for the ratepayers to the ratepayers as the utilities requested, because the utility bill will only include this credit, and any other issue that comes up that should properly be complained from the subscriber to the subscriber organization will be some sort of fee or charge or lack, some lack of action that comes about as a result of that relationship. And this is just saying we think that's clear, and we don't think a rule provision of the rule that says the only complaints against utilities by subscribers shall be regarding the utility bill credit. We could include that. What I'm saying about the bills won't include that language. The fact that they're separate, I think, it would be enough to make it clear to the consumers, the subscribers, that this bill from the utility tells me what I can sue the utility on. This other bill from the subscriber organization tells me what I can sue them for. And so especially the fact that they'd be separate bills would, protect the utility from the possibility or the probability that any subscriber would have an understanding that something on the subscriber organization bill that they could sue the utility for it.
I understand what you're saying. I guess I just, as a maybe, as a harried bill payer, I'm thinking about how it was in the past when I had small kids and lots of things to do. But paying the bills was challenging, and I don't see the harm in putting a small statement on each bill. This is the extent of what this bill addresses. That if you have concerns with, like, for example, if you get a bill from your subscriber, you could say bill credit issues are dealt with between you and the utilities, and look to your utility bill for those issues, or something like that. Something that just points the consumer really easily to the other bill for that issue. You see what I'm saying? I don't see the harm in putting language in. Anything that's a little bit more explanatory rather than silence, I think helps consumers, as long as it's succinct.
Okay, I see, Commissioner. Okay, so what was actually requested by the utility?
And Commission Chair and Commissioner Hall and Commissioners, if I may interject, we're going to be asking we're going to be asking the utilities to devise the solar bill credit as part of their tariffs, and we can also have them put in proposed language that would explain the solar bill credit on the bill. I mean, in very short terms. This is also something that can go on the Commission's website. I talked about the bill calculator that we have is explanatory material. I just want to make it clear is that this particular portion of the order doesn't add anything, doesn't limit what consumers can bring to the commission. And that's what one of the utilities wanted, was to specifically limit the types of complaints. And what we're doing here is declining to do that.
That's
But I
good.
would know, but Commissioner Hall, I would note that, under our, like I said, our regular rules of procedure regarding complaints would continue to apply to all complaints against utilities by the ratepayers, and would include, this new thing on the bill. That would be a new type of complaint, and the only new type of complaint as the utilities put forward. So if we did get a complaint, say from a subscribing ratepayer, and it included, say, a complaint against the utility about the bill credit, and then included some claims against the utility that had nothing to do with the bill credit and really should have been properly brought against the subscriber organization, we would dismiss those with an order that said we dismiss everything but the bill credit complaint, and we say those other complaints are not those other claims are not properly against the utility. So the utility doesn't need a specific rule provision to get that relief from the commission.
No, I'm fine with that. I'm fine with that. I'm not saying, oh, this needs to be in the rule. I'm just saying some language explaining to consumers to whom they should address their complaints before they come to the commission would be helpful. And also it would be a little reassuring to the consumers. You're describing how we can handle the complaints once they come here, but that's hard on consumers when they might have a shorter path to just go directly either to the subscriber or the subscribing entity. I forget what you call them. They're a community solar provider or the utility if they're directed clearly on their bills. That's all I'm saying.
Okay.
That way they don't have to come to the commission and wait till we figure out what to do with them and to whom to send them. That's all. I'm just trying to make it easier on the consumer. But we can move on.
I understand that, definitely. Okay. So but that was a good thing to bring up in this context, because that is exactly, those are complaints about the credits. And that's what we're going to talk about now is the credits. So I'm not going to, I've gone through some of the most pertinent portions of the act, and the fact that the act does go part of the way toward telling the commission what the methodology is for calculation of solar bill credit rates, which are the rates that are then applied to the energy, applied to the kilowatt hours of energy that the subscriber, that are attributable to a particular subscriber in a facility for the energy that's delivered into the utilities grid. In other words, the rate at which an individual subscriber to a facility should be credited for the energy that's coming from the facility into the utility. So that, in other words, the credit for the energy that the facility is producing at the level of the subscriber to the facility. Hopefully that makes sense. So there is quite a bit of methodology that's already provided. This total average retail rate, and it says certain specific requirements and things are included and things are excluded. The big question, and I'm going to turn this over to Art very quickly. Well, first of all, should the commission be doing these calculations or provide only the methodology? It was pretty unanimous, except for one, I think, commenter, that the commission should provide the methodology, and the rule does that. So we'll go to the rule at the end. But the questions were, where is there room with regard to, the things that were left open by the definitions of total aggregate retail rate and solar bill credit rate, and the specifics that are provided in the act. There's still some room for choices with regard to the methodology, and those are areas, particularly the area of transmission costs, where there's the utilities would say there's no choice, and we have a different interpretation, and so I'm going to get to that issue. I think I have next, but the point I wanted to make is that the act goes some part of the way towards specifying the methodology for calculation, but there's some room for decisions, is what I'm saying. Does that make sense? I just want to make it clear that it's not, the act lays out a lot of specifics, but then there are some blanks to fill in still. Would you agree with that?
Yes, and Commission Chair, Commissioners, the two big issues that were left, I guess, subject to discussion within our context, both in the stakeholder group and in the comments on the proposed rule are really kind of like big elements of what the solar bill credit might include. Now, the methodology that was laid out in the act is kind of a subtractive methodology. It says that you will determine what the total aggregate retail rate is, and then you'll subtract distribution costs. But you may include the value of the environmental attributes of the renewable energy certificates that are being turned over to the utilities. Where the dispute was among parties was that the utilities wanted to include the costs of transmission in what was subtracted from the TAR. They made an argument that transmission is part of delivery charges, whereas the terms of the act, the actual wording of the act, just specifies subtracting the distribution charges. So that laid up essentially the two sides. Everybody except the utilities argued that no, the legislature is clear in its intent. If it meant to subtract the transmission charge from the total aggregate retail rate, it would have said so. Clearly, in the operations of utilities, distribution functions and transmission functions are different, right? The utilities, in particular PNM, because it does use some transmission facilities in order to deliver energy within its territory, wanted to combine those two. Our decision, our recommendation to the commission is to follow the exact terms of the act and not take transmission out, because it's actually a significant component of what this bill. It could range between a penny per kilowatt hour and 2.5 cents per kilowatt hour, depending on utility territory, in terms of the calculation of the final solar bill credit. So our recommendation is that transmission, because of the actual terms of the act, should be part of the solar bill credit. Okay. The second element was the value of the renewable energy certificates. And in our proposed rule, we opened the door for consideration of what the value of RECs are now, but also as utilities increase their commitment to renewable portfolio standards, as because of this Energy Transition Act and the changes in state policies, that whatever it is today is going to increase. And we wanted to take that into account. Nobody really provided us any way of doing that. We don't have a good market proxy for what the value of renewable energy certificates are in New Mexico. In providing preliminary estimates, the utilities gave us essentially what the average cost of meeting the current RPS is. And while there's some differences, it's approximately 0.8 of a penny. Okay, so we're adding that 0.8 of a penny to the solar bill credit calculation, opening the door for, in future rate cases, to make this an issue for determination by the commission is what should be the value going forward. But we would at least have a starting point of that. So those are the two big variables in the solar bill credit that we were able to foresee, and nobody proposed anything different. The only other issue was whether the solar bill credit should be based on an average cost or whether it should employ time of use rates. And there were two parties, the rural co-op up at Kit Carson and also Yellowbird Energy Services, that wanted to see a derivation based on time of use rates. Everybody else said that would be really complicated right now because we don't really have good time of use rate structures in the state, but we can leave that open for the future. So those are the three big decisions about the solar bill credit, which is we'll leave it up to the utilities. We'll provide them the methodology. They know what goes into it. We have an understanding based on preliminary figures that they provided us on what that will look like, but make it a tariff so it's subject to commission approval and vetting by the utility staff, right? So that's really what we're coming down on.
Mr. Chair, I've got a question of Art.
Vice Chair Hall, go ahead.
So Art, just with respect to time of use rates, when would we anticipate parties being able to address that? I mean, is that something appropriate for the implementation docket, or is that still too soon?
A time of use
you-
rate structure would be a whole entire rulemaking in and of itself, because this is not the only program that would be implicated by that. And basically what we have in terms of time of use rates is daytime versus nighttime, or peak versus off peak, or some seasonal, right? So it's already complicated given what we have. But given the fact that there will raise arguments that, well, these community solar projects will only produce power during a certain time of the day, that's what the rate should be based on. We don't have the ability to answer those questions right now. So really an average rate is what most jurisdictions use, right? And that's as a starting point. And I guess I should preface this is that part of our underlying philosophy is that this initial period of the community solar project implementation is really a big pilot project, right? We're trying to put it together so that we understand how it works and can deal with these refinements going forward in the proposal to the legislature that we'll make in 2024 based on actual experience in operating the projects and administering the program. So there are just decisions that would take so much time in order for us to determine that they would have delayed implementation. So we took a relatively straightforward path in making those recommendations to the commission.
Again, I would just add, that seems to be contemplated by the act itself. Like we talked about with the statewide program capacity cap, like the commission is supposed to make and would make in this rule an initial allocation of the statewide capacity cap of 200 megawatts. That's like the total cap for the statewide for all community solar projects. That has to be allocated among the three utilities for various projects, each of them having a cap then. And there's an initial one that we have provided, and we'll talk about that later. But the act actually says, by November, November 1st, I believe 2024 is when the commission has to come up with the ultimate decision. In other words, the act is saying, we realize you're going to need some experience to see, how much demand there is in these territories. So when that is reviewed, and there will be some provisions in the rule that we'll talk about later about when that's reviewed, that might be as part of a rulemaking where we also talk about, what we were talking about earlier with regard to whether there are certain subscription agreement terms that should be required, because we see that there are a lot of, yes, Commissioner Fishman suggested maybe do a survey, see what the problems are, maybe do heavier regulation, but targeted toward issues that actually have come up. And other things like that. This like a two-year about initial period of gathering information and leaving it open for now in the rule, seeing if we could deal with them and these things more specifically with more information later, because this is brand new. So I just wanted to add that to what Art said.
Thank you very much. It was a very good explanation. I appreciate it. And I meant to say earlier, I thoroughly support the idea of a survey. I think it's really important to collect data as much as we can about what types of problems are arising in all aspects of this implementation from the get-go, so we can better inform ourselves and the legislature going forward.
I have a question for Art. You had said the estimated value for REX was 0.8 cents. I have 80 cents right here. Should this be a cent sign instead of a dollar sign?
Yeah, there's an inconsistency in what we have. Is that in one at the top of the page here, you're describing it in terms of cents per kilowatt hour.
Let me just copy that in.
Dollars per kilowatt hour. So that essentially the correct is 0.8 cents per kilowatt hour. So you got to lose that. Lose that zero up there.
I'm just going to copy it. Yeah. Yes, I'll just copy it.
That's correct. Right. And we pointed this out. The utilities each expressed it in different ways. And just so that the commission understands is that we are going to be looking very carefully about how they derive the solar bill credit, because this is one of the make or break issues in the entire proceeding that we have. And what we've come up with is an estimation that for residential customers, the solar bill credit is going to vary by utility territory, of course. And it will be approximately 6.7 cents per kilowatt hour to 7 cents per kilowatt hour in SPS territory, 7.3 cents per kilowatt hour in El Paso electric territory. And because PNM has different tiers of customers, it could range between 8.6 cents and 12.8 cents for that. And that includes the transmission, and that includes the estimate of the environmental benefits of the RECs at this point. Different numbers for commercial, but certainly this will be subject to commission review when the utilities provide their tariffs. And at least we went through the exercise twice, in a workshop that you recall, and in a subsequent data request to ask the utilities for their preliminary estimates of that. And so at least we have a guidepost at this point.
And just to clarify for the commissioners, what the act does is it assigns to the utility the RECs that are generated by all the facilities operating in its territory, but then this credit would credit them back as they generate the energy. Is that correct, Art? Did I get that right?
Yes, yeah, and that was we don't have any choice in that.
Mr. Chair?
Yes, Commissioner Fishman.
Russell, I'm looking at your cost for the RECs or your credit for the RECs. Clarify for me, is it 0.08 of a cent or 0.8 of a cent?
It must be this 800s, Art. If you say this number is correct.
No, it's 0.8 of a penny. 0.8 of a penny.
So this should not have a.
No, so it's 0.8 cents.
Correct.
Excellent.
Or
Thank you, Commissioner
if it's
Fishman.
dollars, it's 0.008, right?
Okay. So we had it wrong in one way first. We had it wrong in another way second, but I think we finally got it right. This third way should do it. Okay, so.
Russell, so can you quickly just go to the rule if we're done
Yes.
discussing SBC? Just, and no need to rehash, but that I just want the commissioners to see the format and the content of the rule, the draft rule anyway. This is a good time before you continue, Russell. We've been at it for a couple hours now. I wanted to ask the commissioners in lieu of a break, perhaps we can take an early lunch for a half an hour. Or if you want to continue on and we can break for lunch later. What is your preference? Forge ahead.
Lunch now works for me.
I could go, well, I want to be sensitive to everybody's blood sugar levels. So if the chair needs lunch, the chair needs lunch. But I could also take a quicker period of time. I'd like to get through these things, but if half an hour is all right with me, if that's what we need to do.
I'm just not sure. I think we're going to require a little bit more time to go through this draft rule and all the supporting information.
Oh, I thought we had gone through the rule pretty well. I mean, there
are a number of issues to go.
Okay.
Yeah, and we've covered some of the major ones, but we're about to get to things like selection criteria, and there are a lot of those. If y'all just say these look great, then that'll be quick. But if you don't, it could be a while.
I see. Well,
all right. Well, let's continue, and then we'll see how far we get at noon. Okay, so we'll do a progress check at noon, and then we'll break either way, either for a short break or for a short lunch break. How's that?
Yeah. Fine.
Okay, go ahead, Russell.
Okay, so it says subsection 20, community solar bill credit rate. As I said, there's a defined term in the in the act. But this rate it's really the rate that we needed to give the methodology on, because the rate is what each utility will calculate for itself and then apply to the energy that's attributed to the subscriber that is being generated by the facility that month. So the rate is always times this kilowatt hour thing. So it's the rate that we're telling them how to come up with. Subsection A, this is actually coming right from, I want Art to confirm this for me. This is coming right from the statute. Even though generally our rule for the rule is not to include language from the statute, because this is a calculation and parts of the calculation are specified in the statute and parts were left open, we did recreate that here. Then B, oops, we're going to put in the definition right from the statute. Again, we usually don't recreate parts of the statute, but because this calculation or the methodology for the calculation is partially or in large part provided in the act, and then we're going to be plugging in specific things later in these later subsequent parts, we thought we would recreate those parts in the rule just because then they're right there. And it helps guide us through it. So I need to obviously actually insert the definition here of total aggregate rate. So I will do that. Then C, this is where a choice is made. That because distribution costs, are part of what's included, or I think, excluded from the credit. Correct me if I'm wrong. I think distribution costs, they are actually taken away from the credit because there is distribution involved in the obviously distribution is required for energy that's provided by community solar. Am I correct, Art? So this is
yes. This is a subtractive methodology that the legislature has done. There was an issue, especially with PNM, because PNM's last general rate case was derived by a settlement, and so they did not have a specific cost of service study in order to determine the values of the particular components of service. And what they proposed and what they did in their calculations to us was they went back to the previous rate case where they did have an approved cost of service study and indexed that to a present value. That's the best we can come up with right now, but we hold the door open that the solar bill credit will get revised with each new general rate case. And we would very much encourage specific attention to devising what the values of these components are through a cost of service study in particular, or through an agreement that the commission can say, yes, we see how you got here. Right now, it's just a little bit of a hole, but I think that PNM's recommendation on how to deal with it was reasonable, given the fact that we don't need to relitigate a previous rate case, right, just for this purpose.
And so it would apply the same methodology for all three of the utilities, just some of them are more recent rate cases, so they wouldn't have to do as much indexing, but it would be all three of them will be taking that most recently approved cost of service study as per their most recent rate case and indexing it to current value. On to D. This is.
Hold on, Russell. Commissioner Fishman.
Yes.
Yeah, there's another correction, I think, here. If you're looking at paragraph E, the black print at the bottom, as part of the valuation of renewable energy attributes over the period for reaching mandated 80% renewable portfolio standard by 2030. I think we want 2040.
Right, correct.
Thank you. Excellent. Okay. So going back to D. This is the location of the potential of the dispute with the utilities and the potentially appealed provision. The utility must not subtract any cost of transmission from the solar bill credit calculation. If we could get an appeal from the utilities or some of them based on that alone, because as Art described, they fought that hard, and some of them made the argument that transmission costs that there are transmission costs associated with the community solar facility that are attributable to it. Well, those, of course, our argument, if I make sure I have this correct, energy that's being consumed by community solar subscriber from their own facility, that's what the credit is for. That's what's saving the utility from having to provide that energy doesn't involve any transmission. Obviously, it's local. But the argument that was made, I think by PNM, maybe EPE, was that transmission costs are attributable to a subscriber because the facility is not always producing. In other words, for energy that's not coming from the facility, but from the grid in general. And Art, I think I even have a sense of that, is that the credit is only going to, the credit rate is only applied to the production by the facility. So
that's true, but we're cutting through that and just going with the actual specific terms of the act, which are included in A here, which says that you have the total aggregate retail rate less the distribution cost. No reference to transmission cost, no reference to time of day, anything like that. We can change this in the future, right? And we'll develop experience on it. It could be that the commission directs utilities to have a tracking account or a memo account to decide whether there are significant costs that are associated with that. I don't know how you're going to calculate that on a regular basis, but right now, to start the program, we're going with the way that the act was written.
Okay, and I agree with that as well. I just thought maybe I understood an additional argument that could be made for the appeal, and I was.
So, Mr. Chair,
Fishman.
It's come to that, just Fishman now. There are pluses and minuses on both sides of this. So the fact that you can't do a time of day rate probably hurts customers in terms of the credit they get, at least at the current point in time. And the fact that the transmission's not included, that's a bit of a negative for the utility. But until we can get more granular about this stuff in the future, there's going to be a few things that, if you calculate them specifically, they're going to be to the advantage of one party or the other. But I think they somewhat balance out the way this has been put together. And actually, I wanted to compliment the team on that.
Excellent. Hopefully, utilities will see it that way anyway, and not just attack subsection D. But
Mr. Chair, I just wanted to concur. I think I think there has been a really good job here of, just striking a balance. It can't be perfect. It's not going to be perfect the first time, but once we get more information over time, I think that'll help the commission refine this in a meaningful way.
All right. Anything else on solar bill credits? I just had a format question, Russell. We don't have any definitions in this draft rule. And I see that 573.20 Part B references the definition of the total aggregate retail rate. Is there a need to include definitions in this rule, or are these terms sufficiently addressed in the body of the draft rule?
Mr. Chairman, total aggregate retail rate is specially defined in the Act itself, and a rule that is passed, adopted pursuant to a statute that uses any of those same terms does not need to recreate those definitions. There were no additional terms, specially defined terms, that the team recommends coming up with just for the rule. There are so many specially defined terms in the Act, and those are used here. So when I correct this in B and actually incorporate the definition, it's going to be a specially defined term from the Act. We didn't see any need for any additionally specially defined terms. There are plenty in the Act.
Okay, thank you.
Okay, so with E, actually, I put this in, and I would actually even like Art's input on this when I drafted the language early this morning, that the initial period of the program
I actually put in a date through which it extends, November 1st, 2024. That date is the date upon which two things are required in the act. One, that the commission provide a report to the legislature about the initial period of the program, the overall statewide program. And two, that's the date by which the new caps, any new caps that are determined by the utility for the, allocation of the statewide cap, that also is due by, would become effective after that date under the act. So I actually specified here, and I don't know, I would even ask Art as well, if we would be against specifying that. But I wanted to specify this for one thing and discuss this because we've talked about this initial period. And as I said, it's somewhat defined in the act because there's a report due on a particular date, November 1st. And there's also, that's also the date when the ultimate allocation of the caps is supposed to be determined and become effective on that date. So I actually put a date in there for that. To define what the initial period of the program is. If I don't hear any objections, I'll just go on. This is just this next part. The utility may value the environmental attributes of RECs at the utility's average cost, meaning it's renewable. That's that 0.08 that they've already told us that each utility is going to use. Art didn't want to put an actual number in there, but they've all provided the same number, that 8/10 of a cent, not 800ths and not 80 cents. After the initial period, the utilities formula may incorporate the net present value of RECs as part of the valuation of renewable energy of the period formation. Okay, so it would be updated to determine the next utilities general rate case. I know I kind of blurred through that, but I feel like if there are any questions, I can go to Art on that issue. If there are. That's it for the methodology. So then what would happen procedurally is that the utilities would apply this methodology to create tariffs. I'm just going up to a different part of the rule, including for the solar bill credit rates. And then they would, according to subsection 9, they will file all tariffs, agreements, and forms necessary with the commission within 60 days of the effective date of this rule. And I didn't feel that any specific provisions were necessary for the review. Staff is to review all advice notices that come in and let us know if they should be suspended. The general rule would apply that, that any advice notice for solar bill credit, like any other advice notice, could be effective no sooner than 30 days from filing. So that would give staff sufficient time to review, we think, or if we suspend it for a while for review, we could do that. But that's why there are no special provisions for reviewing the tariffs, because our ordinary provisions should allow for it, and the tariffs will be filed within 60 days, and those will include solar bill credit tariffs. So with that, I could get out of the rule and go back to the order if you would like, and move on to the next subject matter.
Go ahead, Russell, please do.
Did get through a big one there. That was a very big one. But there are a couple big ones ahead too. Let's see, where is it? All right, here we go. Okay. Now the next subject we have under rate making, it's not strictly a rate making issue, but it's a money issue. So it's the level of the application fee or application fees that the program administrator will be collecting. It's not a rate making issue. It's actually something that will be that the program administrator will collect from bidders proposing projects in the bidding process. In other words, subscriber organizations. So it really doesn't have to do with utility rate making, but it was included under that rubric, and we continue to keep the same type of organization. Well, there was a range of things that were recommended. First, I'll go to the recommendation. The team recommends two different fees that be charged. Both of them are non-refundable. The first is a $1,000 non-refundable, let me move this, I can't see this, bid application fee. This is due and payable upon submission
of a response to the RFP solicitation. That's the RFP solicitation that will be conducted by the program administrator for projects, period, for potential projects. So anyone who wants to apply and provide a proposal in response to that RFP will pay $1,000 simply to be considered for by the program administrator, simply to be part of the RFP. Then for those projects that are selected through the RFP process, the bidders for those projects, the subscription organizations, would then pay an application fee in the amount of $2,500 per megawatt. In many of these may be 5 megawatt projects, as Art said, to the administrator within 30 days of the selection. And that's a fee that goes to the administrator. That's separate and distinct from any fee that the project manager or subscription organization would be paying to the utility for interconnection, for interconnection studies. So I don't know if Art has any. This is the part of the process where a project has been selected essentially by the administrator, by the commission / administrator, by these criteria for the project. And then the project, of course, has further hurdles to meet, mostly regarding interconnection with the utility. Is that accurate, Art? Would you say? I'm just trying to describe what happens after the selection, what hurdles they face. They also have to try to attract subscribers at that point.
Yes,
Art,
and just let me explain for the bifurcation of the costs. In referring back to Commissioner Maestas' question earlier, the commission was able to get the Legislative Budget Committee to allow a change in the original terms of this Community Solar Act, which would have required an immediate turnover of any application fees that the commission received to the state treasurer, but did not provide for any mechanism to access those fees. So what the change is that the commission, and Wayne Probst has the specific language, is allowed to retain up to $500,000 of that money that comes in order to run the program. Given the fact that we wouldn't see that money until after projects are selected, we needed a mechanism to have start money in order to pay the administrator. There were proposals for different levels of processing fees from different parties. Mostly these proposals were made before we reached the arrangement with the legislature on being able to retain the fees. So we have this $1,000 application fee, and we have to use the term application fee because that's what the act allows us to charge. And that money will essentially be the seed money for getting the program off the ground. And then as projects are selected, in order to move into the next phase after being selected, and this will narrow down the universe, right, from however many people apply to, let's say, 40 or 50 different projects, that will provide this additional fee that's based on the size of the project. The commission may have to turn over some money to the treasury if it exceeds $500,000, but at least it gives us a budget to work on. Now, these fees are separate and distinct from the kinds of charges that a project, any project that wants to interconnect with the utility will face, right? And those fees are set in existing interconnection rules and in the interconnection rule that is being revised currently, such that things like engineering studies, right, the project developer has to pay. Things like any upgrades to the interconnection, to the utilities distribution system, the developers would have to pay. We do have a mechanism later on in the order that talks about cost sharing possibilities, but basically those are separate fees from what the commission is taking in order to run the program. Okay, is that clear enough?
Thank you. That's very helpful.
Thanks, Arthur.
Okay. Well, if there are no questions, I can move on from there. It seems like the various comments were kind of around those sorts of numbers anyway. So there was I don't think that'll be very controversial. Okay, now we come to another controversial issue, which was just highlighted by Art, cost sharing, or as it's described here, cost allocation. First, you'll see we mentioned the Grid Modernization Act.
Russell,
Yes.
Russell, maybe
Should
you
we-
should address it, the
break.
scenario of if we essentially have a cap of $500,000 and restrictions in retaining anything in excess of that, what do we do if the third-party administrator charges the agency more than the $500,000 cap? How do we pay the third-party administrator?
I'm going to refer to Art. I hope they
Yeah.
don't.
Well,
We have an RFP pending for that.
The RFP has not been issued yet, and
Oh,
I
okay,
think it's,
sorry.
I think it's a determination that we'll make as to whether we specify that we have $500,000 for this, or if we take in competitive bids. Because if we say $500,000, of course, that's what everybody's going to bid, right? Somebody might come in less than that. But in the other short-term contracts that we signed, we risked overstating the $100,000 of emergency funding that we had. And so we went back to the bidders and say, okay, give us your best and final offer. And the ones that were chosen actually came down in their price. Now, there is another possibility here, which is that this is a long-term administration, right? This goes through 2024, essentially. So the commission will have the opportunity to go back to the legislature next year and say, okay, now we see what it's really going to cost us. And this is part of our learning curve. How much is this program really going to cost us? And ask for either additional authority to keep the additional funds that we've raised over and above $500,000, or for a supplemental appropriation for this purpose. That's going to be the problem for the next commissioners, right? And I hate to kick cans down the street, but that's really the best that we can come up with at this time.
Thanks, Arthur. Go ahead, Russell.
Well, I see that we're at noon and we're about to get into a big hairy issue called cost sharing. So this might be a good time. Wasn't that the agreement to take lunch break? Because that's
Yeah,
big issue.
is it okay if we take a half-hour lunch break and then we'll resume at 12:30? Actually, it's a little over half an hour.
Mr. Chair, I agree.
Okay. All right, then we are going to be in recess and we'll reconvene at 12:30.
Thank you.
See you then, folks. Howdy, everyone. Sorry, we're just a tad late. Why don't we resume the meeting? But I wanted to ask the commissioners a question. Since we are not going to act today on community solar, I wanted to ask you all if you wanted to maybe stop here on community solar and resume next week, or proceed until we finish, or we can just set a time stop for community solar to maybe tackle a few other of the contentious issues. What's the pleasure of the commission?
Mr. Chair?
Oh,
I think it's not a bad idea to maybe get to the rest of the agenda simply because they are matters of importance and they're on the agenda, and that would give us some time to, I guess, on our own, review the rule, the remaining parts of the rule more deeply if we haven't already. Wouldn't be a bad use of time to proceed with the rest of the agenda and then see where we are.
I would support that, and also ask Russell, when we do resume, maybe we can dispense with reviewing the feedback from the other stakeholders and jump right to the team recommendations, because oftentimes it does consider the feedback that we got from the other stakeholders. So, all right, so we have any other comments on that? Should we just move on to the next agenda item and resume our review of community solar, the rule, next week? Okay, Commissioner Byrd is okay with that. And are there any objections? Let me ask this too. Russell and Arthur, will you be at next week's meeting?
Yes, I will, Mr. Chairman. And when it comes to, preparing for next week, I'll just, on the memo, I can just highlight where we left off and where we should, if you want to review those parts of the memo, you'll be getting pretty much what I would have said at next week's meeting anyway. So you'll be all ready for next week. We'll go through them, but then we can go through them pretty quickly, and any questions may be already resolved or such.
Okay, this is really, really important. Community solar is, this act it's of great importance to the state of New Mexico in terms of energy justice. The 30% set aside is really important. Many hours, as all of you know, have gone into this effort. through pre-rulemaking stakeholder engagement back when we had strategy on contract. The Community Solar Action Team has been working night and day, sometimes, I guess, Russell, sometimes all night. So I think it's important that we take the necessary time on this. And so if there are no objections, I'm going to go ahead and move on. From a parliamentary procedure standpoint, Judy, are you on, Judy? I don't think we.
Yes, I am on. You would do a motion to table
Okay,
and then table it to next week.
Mr. Chair, I'll make that motion. Oh, what, Mr.
Second.
Go ahead.
Commissioner Byrd, go ahead.
So I'll second the motion that Commissioner Hall just
Okay.
made.
So this is a motion to table until the next meeting. We have a motion and a second. Roll call vote.
Mr.
Yes,
Chair?
Commissioner Fishman,
Yeah, I came in just a minute late. The motion to table is tabling what?
tabling the community solar agenda item until the next meeting. We will pick up where we left off.
Oh, okay. Thank you.
All right, Judy, roll call vote on the motion to table until next week's meeting.
yes. Commissioner Maestas,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar, Commissioner Hall,
Aye.
Commissioner Fishman.
Aye.
The motion to table passes 4-0.
Okay, thank you, Judy. Let's move on to item 6 under regular action items in utility. This is in the matter of 18-00383-UT in the matter of the filing of advice notice number 69 by the Socorro Electric Cooperative. Socorro Electric Cooperative versus New Mexico Public Regulation Commission. Judy, is there any need to tee this up before we go into closed session? Can you give
Well,
us-
what I will say is that this matter comes before you today
Mr.
upon the
Chairman?
new.
Mr. Chairman,
Commissioner Vicente Aguilar.
yes, I was temporarily disconnected and I would like my vote to be counted for the community solar issue that was tabled. I would like my vote to be counted.
Vote is in favor?
Yes, was there anybody that was taking a tally of the vote?
Thank you. So let the record reflect that Commissioner Vicente Aguilar votes for the motion to table in the matter of the adoption of rules pursuant to the Community Solar Act.
Thank you,
All right.
Mr. Chairman.
Thank you.
Sorry to interrupt, Judy.
Oh, no worries. Go ahead, Judy.
Okay, thank you. Mr. Chair, members of the commission, this matter comes before you today upon the New Mexico Supreme Court's January 26, 2020 order, which granted the stay of the proceedings in 2 appeals that were filed by Socorro Electric Cooperative against the commission. There was a writ of mandamus in appeal number SC 38302, and there was an appeal of the final order in SC 37948. The Supreme Court's January 26 order granted the joint motion of Socorro Electric and the commission to remand jurisdiction to the commission to consider modification or withdrawal of an April 2020 compliance order. And it stayed both appeals pending the commission's action on remand. The commission on February 9th issued an initial order on remand requesting the parties being Socorro Electric, Utility Division staff, the City of Socorro, and New Mexico Tech to file responses to many questions that were asked. The reason that we would go into executive session is based upon the Open Meetings Act 10-15-1H to discuss pending, and this is pending litigation or anticipated litigation, and that I request that we go into executive session for those two reasons.
Thank you, Judy. Any questions for Judy? If not, do I hear a motion to go into closed session pursuant to 10-15-1 print H7 regarding threatened and pending litigation?
So move.
Okay, we have a motion by Commissioner Fishman. Do I hear a second?
Second.
We have a second by Commissioner Byrd. Any discussion? Oh, there's no discussion on this, right? Judy, roll call vote.
Yes. Commissioner Vicente Aguilar,
Aye. Or yes.
Commissioner Hall,
Aye.
Commissioner Fishman,
Yes.
Commissioner Byrd,
Aye.
Commissioner Maestas.
Aye.
The motion to go into executive session passes 5-0.
All right, and I guess as we were transferred to a private room on Zoom, Commissioner Byrd and I are physically going to go to a smaller office because the adjacent conference room has speakers that are connected to this whole proceeding. And so we're just going to go to another room. You're going to stay logged in, right?
Yes, sir. I'm already logged in and Sarah knows that to transfer me and leave the hearing room out.
Okay. See y'all in a bit.
Okay.
Thank you.
Actually, so, well, it's back. Actually, so it's solar developers. And according to, maybe I wrote it down. He told me he was not accepting. ENM is not a processing system for tax studies within 60 days. I'll double check on yes, according to my notes from our call yesterday, he said it was I'll double check on this SPS. Cypress Creek and so it's developers. Okay, you got it.
Maybe.
Okay, welcome back, everyone. We're back in open session. All right. Do I hear a motion to come out of executive session and resume open session?
So moved.
Okay,
Second.
we have a motion and a second. And I just want to state for the record, the executive session discussion was limited to threatened and pending litigation pursuant to 1015-1 print H7. All right, Judy, roll call vote, please.
Yes, Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Maestas,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman,
You're muted, Steve.
Sorry, aye.
The motion to come out of executive session has passed 5-0.
Okay, we will not be acting on this agenda item today. So I'd like to entertain a motion to table until next week's meeting. Do I hear a motion?
So moved.
Motion by Commissioner Byrd. Do I hear a second? I'll second that. Any discussion on the motion? Judy, roll call vote, please.
Yes, Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Maestas,
Aye.
Commissioner Fishman,
Aye.
Commissioner Byrd.
Aye.
The motion to table until next week passes 5-0.
Thank you, Judy. Let's move on to item 8, in case 22-00058-UT. In the matter of Public Service Company of New Mexico's application for approval of grid modernization plan. And we have a potential initial order to consider taking action on. Go ahead, Judy.
Yeah, and I'm having a little trouble with my computer, but I'm going to do this from memory. So here goes. Right now, this matter comes before you upon the Grid Modernization Act, which states that the commission, upon request, may ask a utility to file a grid modernization application regarding any of the items that are included within the Grid Modernization Act. And this particular order arises out of the inquiry docket 21-00159, which inquired into resource adequacy for the summer of 2022 and beyond. And PNM has filed many responses and discussing the adequacy for this summer and beyond. And one of the issues that constantly comes up is reducing demand side. And regarding demand side, automatic meter reading has been the subject of 2 other grid modernization applications, one filed by EPE and one filed by SPS. So Commissioner Maestas requested that I draft this order requesting, because that's what the statute says, requesting PNM to file an application and have the application pertain to automatic meter reading and request certain rate making treatment for that. And I stand for questions.
Any questions for Judy?
I'll just, if I may, I'll make a comment.
Yes, Commissioner Fishman?
Is this order covers substantially the same kinds of things that we'd asked for in asking SPS to reapply for its AMI and grid modernization proposal. So,
Yes.
so to me, it makes perfect sense and it's very consistent, and I think it makes sense.
And similar to SPS, we gave them 4 months to prepare it.
Right.
And so I also just want to mention, and all of you know the benefits of AMI, but I think as we're overcoming the challenges that we're facing with respect to supply chain issues and resource adequacy, I think the ultimate scenario is having this technology, the smart meters, to empower ratepayers on making smart decisions for themselves that also benefit the utility in terms of behavioral modification and energy use during peak periods, just as one example. And so I see this as really the ultimate, or not the ultimate, but a very good long-term solution going forward, given everything that's happening today. So I hope you all support this order.
Mr.
Any
Chair.
other questions for Judy?
Mr. Chair.
Yes, Vice Chair Hall.
No, I don't have a question for Judy, but I just wanted to concur in what you just said. You know, there are numerous instances I've read where utilities have managed to achieve meaningful peak shaving through the use of, intelligent demand side management programs. And so it's just, this is like low hanging fruit. As long as they get the right equipment in their hands and use it the way it's intended to be used, not just to replace meter readers, this can be a very powerful tool that's going to support much better reliability and resilience in PNM's entire system. So I think it's absolutely the right thing we should be doing.
Thank you. And I do want to mention this is the product of our weekly meetings focusing on resource adequacy. We have an internal team, and I think you took the words right out of my mouth, Vice Chair Hall, is that this is low hanging fruit. And I think as we look at the immediate situation with summer of 22 and even look at 23, this is really going to help us going forward in the long term, even beyond summer of 2023. So do I hear a motion to approve?
So moved.
Okay, we have a motion by Vice Chair Hall. Do I hear a second?
Second.
Second by Commissioner Fishman. Any discussion on the motion? Judy? Roll call
Commissioner
vote.
Maes,
Aye.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
Commissioner Fishman.
Aye.
The motion to approve the order passes 5-0.
Thank you, Judy. Thank you for bringing that forward. Let's go on to discussion items. John Reynolds, Compliance Action Team, update on status of compliance monitoring and recommendations on Rule 17.1.2.10, Prin B, Prin 2, Prin D, NMAC.
Good afternoon.
Good to see you,
Mr.
John.
Chair and Commissioner Byrd and commissioners online. I'm here to give you an update, as the chair said, about the compliance function at the agency. Last year, or last spring, the commission had expressed some concern about the compliance function here at the agency, which we did not have any. I would say, a dedicated compliance function other than what we do in various cases to review prior orders. So the compliance action team was put together, somewhat informally, and we had a few meetings to discuss the issue and to consider, the challenges and the complexity of starting from scratch to establish an active, or let's say a proactive compliance function. In the process of these discussions, we came across a rule which I was not previously familiar with, and it's referred to here in the agenda. But in short, what the rule provides for is that in utility applications for new rates, which the broad rule is about, this particular section of the rule provides for utilities to include in their applications a review of 5 years of final orders and the compliance status of those orders for the commission to review. That same section of the rule has an alternative that provides for utilities to file such a report annually and dispense with filing it in the rate case. So our thinking at this point is that as a constructive initial step forward to establish a compliance function is to, in short, modify the rule so that the utilities would file in their annual report, which I believe they filed, the significant Rule 510 annual report is due on April 1st, I believe. And PNM does that currently, to file this report annually. And it would essentially allow for sort of the genesis of a new compliance function to begin for staff to begin to review, at least to begin with, the compliance issues related to the investor-owned utilities. More specific, the current rule is in 17.1.2, which is utility applications for new rates. I think there's a good chance that when we go over this in more details, that we should probably strike that the current rule from 17.1.2.10 and then place a different rule requiring an annual report in a reporting section of NMAC. So that's what we're considering. So the next step would be for staff to file a petition with the commission for a proceeding, a rulemaking proceeding to strike the current rule and insert a new section of the rule in the reporting section of the NMAC, implementing what I just spoke of. So that's what we're thinking at this point, and as a starting point, and stakeholders could weigh in, and ultimately the commission will adopt some form of initial step to ensure compliance. But I think at least personally, I feel like without some utility support or some initial step to say this is what we've done to demonstrate compliance with rules, and for us to review that on a predictable, methodical basis annually and inform the commission of what we found, we think this would be a constructive initial step to address the commission's concern about compliance. So thank you, Mr. Chair, commissioners. I'm ready for questions.
Hey, any questions for John on this initiative? So would this be considered like a self-certification?
At this stage, it would be a rule compliance requirement for them to report about order compliance. And so it would be an annual report that would be available and that staff could review and report back to the commission, whether, in the development of this rule, in the rulemaking proceeding I'm proposing, that could be an element in that rule, that there may be some form of affirmative certification of compliance process. And that could be, we hadn't thought it through to that extent, but that could be an element in this proceeding that we're proposing.
Because I like the trust but verify
Right.
philosophy. So, because typically whenever I've seen, I've been in the compliance business as a federal employee for a long time, but you do have your self-certification, but then you always have the authority to go in and audit or ask for more information to get beyond just a self-certification. But I'll reserve my comment until I see the draft rule. But I think this is, maybe it's past due. I've been pretty adamant about the need for greater emphasis and focus on compliance with our orders. Typically, we discover that our orders weren't complied with, but hopefully this will be much more proactive and make all the regulated entities a little more focused in complying with our orders. So anyway, that's all I had. Anyone else have any questions or comments for John Reynolds?
Mr. Chair.
Commissioner Fishman.
Yeah, I'll just say it seems like a constructive start, and let's see where it takes us.
All right, thank you. Thank you, Commissioner Fishman.
Mr. Chair.
Yes, Vice Chair Hall.
Yes, I didn't realize we had such a rule on the books even. And the fact that there is something on the books that says that requires utilities to report on their compliance or failure to comply. Kind of shows that in and of itself, it's not enough, because we already have something, and we're finding that we still have shortfalls. So I think while it's good to have better language in here, sure, I still think we probably will need to develop systems of our own, some sort of tickler files or something to follow individual orders whenever there's a compliance provision in an order, because obviously we can't rely on utilities if we're finding that we're not getting compliance in the face of the fact that we already have a provision that would require it. So I look for better language in the rule, but I also think that we need to come up with some in-house methodology, and it doesn't have to be complex. It could be just a reminder file, on somebody's computer or several parties' computer, maybe, but something that will alert staff when, it's time to look for, a certified letter from somebody saying they've done whatever, or however we require the compliance, and that's the thing. Probably depending on the order and what's ordered, obviously there are going to be differences in what the compliance actions are. So I think we need some sort of a system in-house that will address that need, in addition to the statutory or rule language, that is.
Commissioner Fishman.
Yes. Earlier, Mr. Chair, you'd suggested keeping track of things we need to do with the legislature. Noting those issues and keeping a list. I'm wondering if maybe Isaac and OGC or whomever is appropriate, whenever we create a compliance issue or follow-through issue, could start a tracking list on that, and that might be helpful as well, and it might help John and the compliance action team in putting together their recommendations on rule changes.
John, do you have any comments on that? Because I do agree that there's probably a kind of a clerical element to this, where we essentially create a compliance calendar, and if we can't confirm compliance or there is not compliance past a certain deadline, then whoever is tracking this can alert utilities and the compliance team. And so I agree with that. Do you foresee any kind of, John, any kind of tracking, any kind of compliance tracking?
Mr. Chair and Commissioners, I certainly think it's conceivable as we're speaking about it here today. I do think my initial reaction listening to the commissioners was that I believe that the change from the current filing schedule, which is based on, other than PNM, based on sporadically filed rate cases, to an annual filing, will add some methodical approach to the issue and will allow us to, I think, methodically create tick list, as you say, and then review it a year later when the next filing would be made.
So the compliance filing could actually even include other orders that they intend to comply with. They can summarize what pending compliance orders exist. And by acknowledging it, then they're telling us that we're tracking it. Now, if that would be included too, not just a snapshot of current compliance, but maybe look a year or two into the future and identify any other compliance milestones that they're tracking, I think that could be another level of assurance. Do you agree?
Yes, I agree with that, Mr. Chair and Commissioners, and it's certainly something that could be, that part of the point of the proceeding would be for issues like that to be fleshed out and into a new rule.
So when do you think we'll see this draft compliance?
I expect, I'd have to talk to, I texted Brad Borman earlier in legal, and he was comfortable with my approach. So I would suspect within 3 to 4 weeks, something along that time frame.
Because I will personally hold up your retirement, sir, until we get it.
Well, good luck with that.
I'm just kidding. All right, anything else? Anything else regarding the compliance team and compliance monitoring? Anybody else? Okay. Sorry to put you on the spot there, John. Thank you, though. Thank you. This is at least exactly what I'd like to see in this agency. So with that, let's move on to communications with the Chief of Staff. Good afternoon, Wayne.
Good afternoon, Mr. Chairman, Commissioner Byrd, and the Commission. I don't have a lot for you today. Just wanted to mention, I had noted it a couple weeks ago that I was able to do a railroad inspection. This last week, I was able to do a tow company inspection here in Santa Fe with Fidel and Molly. And I will say, Mr. Chairman, it was a fascinating look into a whole different world that I knew nothing about. And so going to continue doing that. I think I still have an ambulance inspection and maybe a pipeline safety inspection at some point here in the future, but we'll reiterate that if anybody has time to do something like that, it does. Certainly I learned a lot about what we do as an agency, how important it is. Tow trucks, you kind of take them for granted, but they are big things and lots of things can go wrong. And if somebody's not taking a look at that, people can get hurt. So again, just a very fascinating look into what we do here as a PRC. The only other thing, Mr. Chairman, and you just kind of alluded to it, I know the Commission is aware and staff is aware, but we have a couple of very senior staff members who are going to be retiring at the end of this fiscal year, Ashley and John. And Mr. Chairman, if you're going to hold up John's, I would also suggest you hold up Ashley's. But certainly well-deserved retirements. Will have time to celebrate their contributions to the Commission and wish them well, but did want to note those two personnel matters. And also a third one, Mr. Chairman, the Commission is aware of that Sarah is going to be transitioning to a new position here at the commission, away from being our public information officer into being one of our HR professionals. Excited for her and that opportunity, and really happy to be able to keep her with us here at the PRC. All of those positions, well, with the exception of John's, because we just learned about that one yesterday, but Ashley's the chief hearing examiner position has been advertised in SPO. It will be advertised in the state bar bulletin, I believe, on the April 13th edition of the bar bulletin. We were able to get it up on the NARUC site today as well. And the PIO position has also been posted through SPO. And we'll include those on our website if they haven't already been put on our website. So a couple of positions to fill moving forward, but just wanted to make sure that everybody was aware that we're already working on that, and happy to answer any questions or discuss any other matters that you have, Mr. Chairman.
Okay, any questions or comments for Wayne?
Yeah, Mr. Chair.
Vice Chair Hall?
So, Wayne, I was just curious, do we advertise in places like LinkedIn or other places online?
Mr. Chairman and members of the commission and Commissioner Hall, if we haven't, we will. That's something we've been doing with the technical advisory positions through Indeed and LinkedIn. So I'll have to check with Renee to see if we've done that, and if we haven't, we'll get that done.
Yeah, thanks. Just wondered, I get a lot of notifications about all these jobs I don't want, but it looks active on that website.
Yeah, absolutely.
Yeah.
Thank you, Vice Chair Hall. Any other questions for Wayne? All right, thank you, Wayne. Before we go to communications with Office of General Counsel, I'd like to go first in terms of communications with commissioners, as I've got to leave like right now. But I wanted to pitch an idea to the commission for having our April 27th meeting up in the Four Corners area. I am making arrangements to tour San Juan Generating Station in the afternoon of the 27th and tour the coal mine in the afternoon of the 28th. So I would essentially be there probably until Friday. But I think it would be very good for this commission to begin taking its meetings on the road. And given the recent cases and all the attention in the Four Corners area, I think it would be fitting for us to be there. I realize this is Commissioner Vicente Aguilar's district. But I wanted to see if there was any interest in having our meeting there, actually in the consolidated school district. One location that's been suggested because of its proximity to San Juan Generating Station is the Bond Wilson Tech Center. So it's more than a month away. I think it gives us time to think about it. I've already discussed potential logistical issues with Judy, but I think it doesn't do me any good to discuss it if there's no interest on the part of the commission. But if there is no appetite for doing that, then I'll just tune in via Zoom from the Four Corners area for our April 27th meeting. So what do y'all think about that? I think Commissioner Byrd is nodding his head in the affirmative.
So am I.
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
I'd like to ask General Counsel's office if they have any pending cases that we should not be talking about during the open meeting, or if we're in the vicinity of the Four Corners. Maybe that's a question for Judy, or
Yes,
I'm not sure who can answer.
Commissioner, we do have a pending case on the Four Corners application. And I know that there was an order, and I'm not sure exactly if it disposed of the whole case. I don't think it did. And so that might be one of the cases. there are compliance issues regarding the San Juan generating station. But that case is not in litigation. There is one case, 1918, that is in litigation regarding the securitization. So I think it would depend what issue you're talking about. And maybe before we have that meeting, if we do have it up there, we can give you more exact parameters.
Okay,
That would be great, Judy.
all right, anything else on this?
Mr. Chair?
Yes, Vice Chair Hall.
Well, I'm going to be unavailable. I'm going to be at a California Clean Energy Procurement Summit that starts on the 27th. I'm a speaker on a panel on the morning of the 28th, and I was going to come back that day. And I thought that was an interesting summit to go to because it involves discussing not just California, but other Western states' aggressive efforts to procure clean energy and energy in advance of, going 2 years out, actually, for California. I think they're going to they want to buy ahead 2 million gigawatts. I mean, wait a minute, let me get that right. 2 gigawatts. So I want to go to that because it has direct bearing on our efforts to try to get a handle on resource adequacy here. We got to see what everybody else is trying to buy in the West. But I also have committed to a panel. So I won't be able to go unless we have our meeting on a different day earlier in the week. Then I could go.
All right.
So you might want to think about if that would be possible. I'd be interested to go otherwise.
See y'all next time.
Oh, yeah, I gotta go.
Take care, Joe.
Well, I could continue that with other commissioners if anybody else was willing to have our open meeting on, say, Tuesday or even Monday, then I could go and still meet my commitment later that week. I think it would be kind of,
Hall,
yeah,
Vice Chair Hall.
yes.
I think we need to plan this out during the open meeting. So that we have a schedule to go to different districts. It was not formally announced. I don't know. What does everybody think about this?
I like the idea of planning it out in an open meeting so we have a schedule. And I assume you're talking about going to different parts of the state for different meetings. Is that correct?
That's correct. Commissioner Byrd mentioned this at the beginning of the year, 2022. Mm-hmm. He said he was interested in moving our open meetings to, different parts of the state. So we are interested, but it just needs to be planned out, Vice Chair Hall.
I agree. That would be helpful to me too. And but I do like the idea of going to, especially the Four Corners site, the school district. I think that would be good for us and good for the community. And I'm quite open to going other places as well. But I appreciate your thought about planning it out so we have dates that work for everybody.
And the reason that I'm speaking out is because, we would like all the commissioners to come to these meetings because the state legislatures from that area, they attend the meeting, the county commissioners, and everyone is invited. So I would like to suggest that maybe we can start planning and plan the Four Corners open meeting maybe the first week in May or the second week in May. That's just my opinion.
Mm-hmm. Yeah. That sounds fine with me. Any other comments from anybody? I guess I'm chairing
Yeah,
the rest of the meeting.
I'm comfortable with it. I think
Okay.
that's a good idea.
Okay, Jeff, you got a thought?
We have thoughts.
Would you like to share it on this topic?
And Commissioner Maestas had mentioned to me anyway, that he's wanting to do more of the roving meetings again. And the opportunity to go to San Juan had come up for us to tour it. So he thought, well, let's do the meeting there, do the tour and kind of get more involved while we're there in the community. And that's why he's pitching it for that particular day, but he is interested in doing other roving meetings throughout the year. So anyway, I'm in favor of it. I'm planning on going.
Great. Okay, well, any other communications with commissioners?
I'd just like to express how much I'm going to miss John Reynolds and how much I'm going to miss Ashley Shanauer. Both people who I can't believe the amount of work that they get accomplished for the commission. Just extremely productive folks and courageous folks. We've all gone through the Avangrid issue and the San Juan replacement issues and tough decisions where there's a lot of disagreement. But I know that just Ashley showed incredible courage and independence in looking at the evidence and putting together decisions for us. And he will be sorely missed. And I just want to also express, John knows how to stick to his guns too. And that's a rare trait these days. People go along to get along and sometimes go along with something that just doesn't make any sense. But Ashley and John truly have the courage of their convictions, and both people that I greatly admire and will sorely miss. I'm done.
Thank you, Commissioner Fishman. I completely concur. I have to say the feelings I had both when I heard Ashley was retiring and then John was sadness and anxiety, because they do so much and they produce such good work and they'll be gone. So we just have to press on and find more talented people out there. But I agree, they'll be sorely missed. Any other comments from any? Yes, Commissioner Vicente Aguilar. Yes.
I would like to speak on the subject about two of our key staff members that are going to be retiring in June. We've all worked together over the years, and patience was number one with these two wonderful gentlemen. One in the hearing examiners section and the other is in the utility section. And I think Public Regulation Commission is evolving, and a lot of our staff members are coming into a decision, and I am very happy that they're going to retire soon so that they can spend more time with their families and other adventures in, whatever their interests are. But the important part is that we will have another staff member that will have the same type of talent, just like the ones that John Reynolds has, and also Ashley Schnauer, because I think when people come to the commission, it's challenging, it's technical, it's utility business, and we look for the best. And I think we'll strive right through. And the other part that I would like to say is that all the staff members, we don't see how much work they are completing every day, but we get a sense, and it's solidified in documentations, and they have carried us. They have carried us as commissioners, and I have to say thank you. Thank you very much to all our staff members on this point, because to lose two that are at the top level, we have to be honored. We have to feel good about it, but we got to have hope that we will find talented members that will be coming to replace their positions. And I'd like to thank our chief of staff for assisting us as commissioners. And it's not an easy job. And that's my comment, Vice Chair Hall. Thank you.
Thank you, Commissioner Vicente Aguilar. Well, Commissioner Byrd, do you have anything you want to state while we're at it?
Yeah, they're not leaving for a couple months, so I want to harass them some more. So
Okay.
I'll leave it for later. Thank you.
Sounds fair. Okay, well, I think that's it for the agenda. So,
No, ma'am. Madam Chair,
what?
I'm
OGC.
sorry. I'm sorry, Commissioner Hall, but I have one matter I have to bring up.
Oh, okay.
I received, and I communicated by the phone as well. I received an email from Austin Rauschhoff of Holland and Hart, who represents the New Mexico Large Customers Group. And they are inviting all the commissioners to their meeting on April 14th in Santa Fe, and they want to send an invite. And I said that if more than 2 commissioners joined, that would be a quorum and it would have to be noticed as an open meeting. And they asked about scheduling separate meetings. And I'm not even sure more than 2 commissioners would like to attend, but you will be getting an invite, and I just wanted to let you know, and then we can figure out if there'll be more than 2 commissioners attending, how to handle that. But the first step is just to let you know that you will be getting an invite for April 14th meeting of the New Mexico Large Customer Group in Santa Fe. And there will also be remote participation available as well.
Well, thank you for that information, Judy. I appreciate it. And I guess we should just wait. I think we should do what you say. And if anybody else has any comments about it, please chime in. But my opinion would be, let's just wait and see how commissioners decide once they get the invitation. Anybody have any other comments on that? I don't think I'm going to go. But other commissioners? No comments?
Don't know yet.
Okay. Yeah. All right. Well, if that's it, I think we're adjourned. Bye.
Take care.